I'm sorry.
ಹತ್ತುವರೆ ನಾನು 9:30 ಹೇಳಿರೋದು ಹೋಗ್ತಾ ಇತ್ತು.
ಇಲ್ಲಿ ಇದನ್ನ ಮಾಡಿ
ಅದನ್ನ ಸ್ಟಾಪ್ ಮಾಡಿದ್ರೆ ಕಂಪ್ಲೀಟ್ ಮುಗ್ದೋಗುತ್ತೆ. ಮತ್ತೆ ಅಪ್ಲೈ ಮಾಡಬೇಕು ಮತ್ತೆ
ಇಲ್ಲ ನಾನು ಮಾಡಲ್ಲ, ನಮ್ಗೆ ಗೊತ್ತಿಲ್ಲ ಅಕಸ್ಮಾತ್ ಅವರೇ
Monday and Tuesday.
Sir, matter
Monday and Tuesday.
State will be directed. We have some urgency. There is stay granted.
Okay, sir.
Monday and Tuesday. Tomorrow, all the matters, I think. Yesterday, same number of people, advocates. Tomorrow. Around tomorrow. Yesterday, you moved it. Yes, tomorrow. Tomorrow, sir. Tomorrow. Yes, sir. Why? What is? Nothing will happen. Nothing will. Monday, Tuesday, told. Nothing. Not tomorrow. Please give. Next. Nothing. Next.
Application for need of the document has been rejected.
Tuesday. Give Tuesday. Yes, madam. Yes, madam. Yes. Tomorrow too. And since it is yes.
This are also granted to rule to see and also granted to share. In spite of the matter, the transport is resonating and not at the main matter. Today it's set down for further. Therefore, kindly tomorrow.
Tuesday too. Tuesday.
Yes, the documents have been set up.
Yes.
Documents have been taken as bill. Final documents have been taken as bill. And it has been posted today for the respondent argument. If the respondent address argument, it will be posted for judgment. At least tomorrow.
Tomorrow. No. Nothing will happen. Tuesday. Monday, Tuesday. Next. Tuesday.
Sir.
What's your urgency? Yes, Mr. Sharath. Mr. Sharath, you are insofar as disturbing us. Nothing else. Only urgency is next week. Yes. Nothing. Told him Tuesday. No, Tuesday. Yes. Yes.
Adjournment, page wise, serial number 26 and 27, page number 5, serial number 28 to 41, serial number 28 to 41, serial number 42 to 51, serial number 42 to 51. Any adjournments?
Any adjournments?
52. For order, serial number 1.
In this case, I am for respondent lordships. Lordships, the respondent has filed a suit for specific performance.
Just a minute. Non-rectification of office objections raised on IA 1 of 19. What is this IA 1 of 19?
So the IA has been disposed of because of thing is that lordship interim order not been extended. Interim order is not extended earlier point of time. The respondent has filed a suit for specific performance. It came to be settled before the mediation. Amount of rupees 5,30,000. And lordship, the petitioner has paid 1,80,000 and he has remaining balance of 3,50,000. And we initiated execution proceedings. In the execution proceedings, he has
1 minute.
The amount earlier deposited has been withdrawn, and as on this day, the petitioner has due of rupees 1,50,000. And 2014 matter lordships execution. 2014 matter lordships.
What is the matter actually? What is the matter?
Lordship, the suit for specific performance filed by the respondent herein against the petitioner. Either you can speak or you can. Which petitioner? Yes. I am for respondent lordships.
Just wait for some.
Yes, Lord.
Where is the mediation order? Where is the decree? Annexure C page.
Page number 21.
Yes, next. What has happened? What's the decree? Pre-installment data so and so 1 lakh on so and so 50,000 and so 1 lakh 80,000. The agreed amount of file as per the mediation report. The defendant paid only 1 lakh 80,000 instead, not paid the entire as agreed by them. So what has happened?
Remaining 3,50,000 and room.
Yes.
On that decree allotted in the execution petition filed by the plaintiff respondent. At the time of the
So remaining 3 lakhs 50,000 that you have to pay.
meanwhile, 1 lakh already deposited for the right.
Your deposits at the
And the remaining 2 lakh 80,000 out of that 1 lakh 40,000 already deposited as per the contract. In the remaining 1 lakh 40,000 is due from the petition.
then you have to pay. When was the order passed?
In the
2014, Lord.
Yes. Just,
2019.
then you are not paid. Then what is the wrong? What is the error committed by?
2019.
No. The decree is passed on 15th October 2014. Nearly 7 years. It's not a case for interference. Not a case for interference. 2017 decree agi 7 years.
14 Lordships.
2014 order.
8 years Lordships.
Yes. 7 years you have not obeyed the bill. No.
And as per direction of dishonorable court, already 1 lakh 40,000.
There is no error committed by the. No. Where is the impugned order? Attachment 18/4/17. Dear absent. Issue warrant for attachment of immovable property. Annexure 18/4.
Page number 35.
35. Order dated 18/4/2017 is charging. What is the error in the order?
Already settled before the mediation.
No, settlement only. Yes.
Property value is more than 15 lakh. Remaining on total 1 lakh 40,000.
You pay. I will dismiss it.
4 weeks time.
Not 4. Already you have taken 7 years. It is not the way in which you have to do. Told you.
And submission Lordships.
4 weeks time.
See, since 2014, you have not obeyed the mediation report. Order pass. Order in the mediation settlement actually. So why we have to? See, 7 years you took. So 1 month to 1 week, 2 weeks. No. Now I cannot give. Come little down. 1 week. No, 1 week you can pay. No, it's a very small margin is there. Told you. 1 week time I will dispose of this. After arguing for some time, full stop. Told you. First of all, this writ petition is filed by the judgment debtor against the order dated 18/4/2017 in execution petition number 89 of 2014 on the file of the principal civil judge in bracket junior division and JMHC at Kolar. List of perusal of the writ petition would indicate that, the plaintiff has filed a suit for specific performance, directing the defendant to receive the balance sale consideration of ₹1,21,000 and to execute the registered sale deed in terms of the registered agreement of sale dated 29/7/2008. Full stop. The full stop. During the pendency of the suit, the matter was settled between the parties and it was decreed that the decreed as follows. Page 21. Extract. Full stop. Thereafter, the plaintiff, thereafter, the judgment debtor has not obeyed the judgment and decree, and pursuant to the same, the respondent herein has filed execution petition number 89 of 2014 on the file of the trial court, and the trial court by order dated 18/4/2017, allowed IA number 2, and pursuant to the same, issued warrant of attachment of immovable property, full stop. Feeling aggrieved by the same, the judgment debtor has presented this petition. After arguing for some time, Sri Narasimhamurthy GV, and the counsel appearing for the petitioner, seeks 1 week's time to pay the entire amount with interest as per the decree dated decree dated 15th October 2014. Looking into the averments made in the writ petition and considering the submission made by the Lana counsel appearing for the respondent, this court is of the opinion that 1 week time shall be given to the judgment debtor to comply with the decree dated 15th October 2014, failing which the execution court shall take appropriate steps against the respondent / judgment decree holder is permitted to take necessary steps against the petitioner. Accordingly, the writ petition is disposed of. Yes, 1 week from today.
Respondent.
Any amount is deposited here. Any amount is deposited here is released to before it. Very good. Yes, sir. What is challenge, sir?
The impute order is a direction A. It's 15. Next B. The petitioner hearing had filed a suit seeking the relief of declaration of society, cancellation of the sale deed, and for permanent injunction.
Just HT Narayan. Yes, you are ready? Ready, sir? You are also ready? Then I will take it up. If you are ready, I will take it up. Yes, then. Okay. When both of you are ready, then okay. So you are the defendant before the trial court.
So far as this annexure A is concerned, I am the defendant. But you are not the candidate to annexure G, page 40. I had filed a suit against the defendant's name, seeking the release of declaration of title, cancellation of the sale deed, dated 26/1967, and for permanent injunction.
So OS 7 of 2015 is filed by you.
OS 7 of 2005. I had filed.
Yes.
And the plaintiff in that suit.
Seeking, what is the relief? What is the relief? Yes, I have. What is the relief? What is the relief that you sought?
In that suit, I sought the relief of declaration of
Relief
the
of-
title.
Yes.
Then
That is OS 7 of 2015 is filed by the defendant in OS number.
OS number 7 of 2005.
Yes, sir.
This suit came to be decreed. So what we find the decree at annexure E, page 47.
47
Please.
on 25th 7 2009.
Those up to page, the operating motion, you will also find it at page 73.
73.
73.
Yes, sir.
This decree was in respect of only some of
So
the
that
items,
is
but some of the
declared
items
that-
of property that left in this decree.
Plaintiff is-
Therefore, I can find the appeal in the RA
Yes.
28 of 2009. You also find that annexure F.
So you preferred RA.
I had preferred RA because it was only a partial decree. Therefore, I had preferred RA.
RA 28 of 2009. Yes, sir. What happened in RA? It is pending?
RE is still pending.
Pending.
It is in respect of very same property.
Yes.
Now, my lord, the respondent herein had filed an independent suit. The lord will find the annexure C.
33 of 18.
Page 33 of 2018. Page 34.
Suit for?
Suit to declare that the decree passed in Mysore is obtained by paying fraud, something like that.
Yes, sir.
You must will find the fair column at page 37.
37.
Page 37. In this suit, my lord,
Yes.
in this suit,
So cancellation of the judgment so and so.
yes, my decree here sought for cancellation of my decree, which is passed in the
Whether it's a party in your suit also?
in my suit, he was not the party, my lord. He had sought this relief. Here, my lord, in this suit, he had sought for injunction, temporary injunction, irrespective of the same problem.
Yes, sir.
The trial court has rejected it. Against that, he had filed the appeal. The appellate court granted. In the meanwhile, my lord, in my pending RA, he had filed an impeding application that has been allowed and he has been appealed. Now, in my appeal, he is a party. So, your lordship may kindly consider.
Yes.
The appeal is the continuation of the original proceeding.
Yes.
So, the appellate court can pass any orders as if it is the having original jurisdiction.
Yes, sir.
Now, my lord, my appeal is pending. He has a sought for cancellation of my decree passed into OS. Now, in my appeal, he is a party. Therefore, whatever is there, he can seek the relief in my appeal itself.
Correct.
In spite of that, my lord, he files an independent suit wherein the case was refused. But the appellate court.
Yes, if any order is passed by the first appellate court, it is binding on him also. Then the independent suit, that is 33 of 2018, does not survive.
That's not correct.
Correct.
Now, the reason is right by the learned judge, you will also find it at page 23.
Yes.
Page 23.
Whether is impleading applications allowed in the area? Allowed. Now he's a respondent.
He is the respondent. In the
Yes.
respondent number 6 in that.
Yes.
appeal.
Yes, sir.
In the page 23, you will also find the finding of the learned judge.
20?
23.
Yes, sir.
In page 20. Fourth line. The plaintiff has sought for the relief of cancellation of the decree OS number 7/2005.
Yes.
There is also an appeal as claimed by the plaintiff in RA number 28/2007. So he is aware that the appeal is also pending. Under such circumstances, considering the assertion made by the plaintiff and the contention raised in the defense, the plaintiff has clearly made out a case triable in his favor. Now, the lordship will kindly appreciate the aspects which require to be considered while granting temporary injunction. Prima facie case, balance of convenience, and irreparability. That is the consideration for granting injunction or refusing injunction under alternate instrument. Now, the learned judge says decree is passed, appeal is pending. In that appeal is also a party. Despite that, injunction is granted. In a parallel suit, injunction is granted. Therefore, my humble submission.
Correct.
So this,
Yes, sir.
Lord, on 26/11/1989, plaintiff in OS 33 of 2018 filed OS 268 of 1989. The suit was filed as against the petitioner herein, who was arraigned as second defendant. The suit was decreed in part.
What is that 268?
OS 268 of 1989.
This is the third suit actually. 89.
89 suit, first suit.
Yes, sir.
This was filed by the respondent as against the petitioner herein.
Filed by respondent means?
Respondent before this court.
Respondent means yourself. Yourself.
Yes. The petitioner was arraigned as second defendant in this suit.
So what happened in the OS 268? Whether the petitioners herein is a party?
Yes, petitioner herein is a second defendant in this suit.
D2. Yes, sir.
And suit was partially decreed, my lord. Out of 11 properties, the plaintiff was held to be the absolute owner.
Yes.
In possession of 6 properties, which are the subject matter of this suit, OS 33 of 2018.
Whether the said decree was challenged?
Yes, my lord.
In appeal?
In RA, and regular appeal was also allowed.
Regular appeal is?
RA number
69 now.
69 of 2003, my lord.
69 of 2003. Next.
My lord, suppressed.
RA was dismissed. Huh?
RA was partly allowed.
Partly allowed. Yes.
Suppressing this decree, my lord, the petitioner has filed OS 7 of 2005.
Okay.
In respect of the same set of properties.
Yes.
I have not been arrayed as defendant. I have not been.
Where is the plaint? Where is the plaint in 7 of 2005?
Not forming a part of records.
You have a plaint, sir? Plaint in 7 of 2005? If you say suppress, then you must have a copy of the same.
I'll file it.
If you say that you suppress the filing of suppress the OS 268 of 89 and RA 16 of 2003,
Yes.
and he has filed another suit in OS 7 of 2005, you must have a copy of the plaint. Just we can see whether he has stated anything about these proceedings in the OS number 7 of 2005.
I'll have it filed. I have filed the judgment and decree granted in favor of the respondent in OS 268 of 1989.
Whether he has taken a plea in OS 7 of 2005 regarding OS 268 of 2018.
Yes, my lord. That is the ground on which the judgment and decree is sought to be cancelled and not binding on the plaintiff.
Yes.
Because the plaintiff was not made.
You have a copy of the same thing? Plaint in OS 7 of 2005. Yes, sir. And page?
In page 40, my lord.
40.
My lord, though the
Just a minute. Have you stated about OS 268 of 89 in the plaint?
No, my lord.
In which, just a minute, in which you are the defendant number 2 and also RA 16 of 2000. Have you stated or not? Have you stated or not? Then you are suppressed. Then you are suppressed.
Now, merely because the other side says that there was an earlier.
Of course, OS 268 of 89. You are a defendant number 2. And thereafter, that has been partly allowed in RA 69 of 2003. See, this is the equitable relief. 39 rule 1 and 2 equitable. You have to approach the court with clean hands. Yes, I don't find any. I don't find any.
1989 is concerned, I don't have any knowledge about that suit.
You are a defendant number 2. You are a defendant number 2.
That copy has not been produced before.
You are a defendant number 2.
That has not been produced.
You are a defendant number 2.
The assumption of my other friend who is on the other side. But that copy has not been produced before this one.
Yeah.
It is not part of the record.
Yes.
They have not filed any objection and they have not produced.
Irrespective of the same, you must have stated in your suit OS 7 of 2005.
Now, so far as OS 269 of 1989 is concerned, I am not aware of the fact and therefore, with great respect, my submission is I am unable to make any submission.
Yes.
So perhaps that should be concerned.
Yes.
But at the same time, my lord, here, my lord, the decree is passed in my favor, which is challenged by me in the, since it is a partial decree, I have challenged it in an appeal wherein he is also the party.
Yes.
Whatever may be his defense, he can take it in that appeal itself.
Yes.
He can plead it before the appellate court.
Yes.
He can having the right to urge all the grounds,
Yes.
including that of this OS 268 of 89 also.
Very simple. Have you stated in OS number 7 of 2005 relating to OS 268 of 18?
Not in this claim, annexure D, it is not seen.
Why? Why you should have? You should have. Because that is what page para 18 of the first appellate court has stated. Sorry, sir. Not a case for interference. This writ petition is filed by the,
May
yes, sir.
I'm sorry. In page 18, there is no reference to that other footnote.
Para 18.
Para 18.
RA 69 of 03 and 8. Seventh line. Para 18, page 24. That's what the first report has referred to. This is what you are suppressed in your suit. This writ petition is filed by the defendant in OS number 33 of 2018 on the file of the civil judge and JMFC Nagamangala, challenging the order dated 25/4/2019, passed by the senior civil judge and JMFC Nagamangala in MA number 8 of 2018, allowing the appeal and granting temporary injunction in favor of the respondent in respect of the suit schedule property, in respect of the subject matter of the suit. The brief facts for the adjudication of this writ petition are that the OS number 33 of 2033 is filed by the respondent herein, seeking relief of declaration in respect of the suit schedule property. The plaintiff has filed IA number 1 under Order 39 Rule 1 and 2, seeking temporary injunction against the petitioner herein, which came to be dismissed by the trial court by order dated 27 June 2018. Being agreed by the same, the petitioner herein has filed MA number 8 of 2018 on the file of the First Appellate Court, and the First Appellate Court, after considering the material and record by order dated 25/4/2019, allowed the appeal and as such set aside the order dated 27 June 2018 passed by the trial court. Feeling agreed by the same, the present writ petition is filed. I heard Sri M.J. Alwal and a counsel appearing for the petitioner, and Sri H.T. Narayan and a counsel appearing for the respondent. Sri M.J. Alwal and a counsel appearing for the petitioner, submitted that the trial court failed to consider the fact that the OS number 7 of 2005 was filed by the petitioner herein against the defendants seeking relief of declaration, which came to be decreed on 25/7/2009 and against the said judgment and decree RA number 28 of 2009 is filed before the First Appellate Court, and same is pending consideration before the First Appellate Court. The further contended the subject matter of the subject matter in OS number 33 of 2018 is also the subject matter in RA number 28 of 2009. And since the said RA number 28 of 2009 is pending consideration before the First Appellate Court, the trial court, after considering the material on record, rightly dismissed the IA number 1 filed by the respondent herein in OS number 33 of 2018, and the said aspect has not been properly appreciated by the First Appellate Court in MA number 8 of 2018. Accordingly, sought for interference in this writ petition. Per contra, Sri H.T. Narayana and the counsel appearing for the respondent, contended that OS number 268 of 1989 was filed by the respondent against the petitioner hearing, and he has been arraigned as the defendant number 2, and the said suit came to be decreed in part, and being agreed by the same, the RA number 69 of 2003 was filed before the First Appellate Court, and the same was partly allowed, and same has reached finality, and the said aspect of the matter was not stated in, was suppressed by the petitioner's hearing in OS number 7 of 2005, and therefore Sri H.T. Narayana and counsel appearing for the respondent contended that the equitable relief under Order 39, Rule 1 and 2 cannot be extended to a litigant who has suppressed the fact before the trial court. Having heard the Lana counsel appearing for the parties, and in the light of the fact that the OS number 268 of 1989 was filed by the respondent hearing against the plaintiff/petitioner in this petition, and the petition herein has been arraigned as a defendant number 2. The said suit came to be decreed in part, and the RA number 69 of 2003 was filed against the said judgment and decree passed in OS number 268 of 1989, which was partly allowed. Full stop. The said aspect of the matter, full stop. In the light of the submission made by the Lana counsel appearing for the respondent, I have carefully considered the plaint averments in OS number 7 of 2005 filed by the petitioner hearing. Full stop. Perusal of the entire averments in the plaint would indicate that the plaintiff has not suppressed the proceedings in OS number 268 of 1989 and RA number 69 of 2003, despite the fact that the petition herein has been arranged as the defendant number 2 in the said suit. It is well established principle that the granting or refusing of the temporary injunction is equitable in nature, and if the plaintiff who seeks an temporary injunction has to approach the court with clean hands. Full stop. Full stop. Having said so that the plaintiff/petitioner hearing defendant, having said so that the defendant has suppressed the decree passed by the competent court in OS number 268 of 1989 and RA number 69 of 2003 in OS number 7 of 2005. I am of the considered view that the First Appellate Court was justified in allowing the appeal, and accordingly, I do not find any acceptable ground to interfere with the impugned judgment and impugned order passed by the First Appellate Court. Accordingly, writ petition is rejected. Finally, 2 weeks. Finally, 2 weeks time is granted to comply with the office objection. Yes.
Yeah, I appear for the petitioner, my lord.
Memo reported death of respondent. Yes.
I seek 2 weeks time to take steps, my lord.
Then a counsel appearing for the petitioner filed memo reporting the death of the respondent and seeks 2 weeks time to file necessary application to bring the legal representatives of the deceased respondent. So list after 3 weeks.
I mean, IO may be continued till next date.
The order granted earlier extended till next date of law.
I have filed getting interim order.
Yes, but the respondent is died, sir.
Yes, ma'am.
So respondent died means your wakalat cannot be considered.
Your Lordship.
Huh.
Serial number 5, my lord.
Huh.
I'm for the petitioners, my lord. All
Yes,
the office objections has been complied with, my lord.
Huh.
And a memo regarding the respondent as second respondent had passed away. And the petitioners who are his LRs are already on record, my lord.
You complied with them.
Yes, my lord. All the office objections have been complied with, my lord.
On the last year, that is on 17/2/2022, this court decision the office objection not complied within such period. 1 week you are complied with.
Yes, my lord. It has been complied with.
Council applying for the petitioner submitted that pursuant to the order dated 17/2/2022, yes, complied with the office objection. Registry is directed to verify the same. Yes.
Much obliged, my lord.
Yes, Mr. Nandish Koda.
Appearing for
Yes,
petitioner, my lord.
yes.
Interim order,
What is the writ petition actually?
my lord, suit for declaration and injunction. The
You are-
proposed defendant number 2 and 3, my lord, filed the application for impleading. Their contention is that, my lord, they have first respondent herein has executed a registered agreement of sale in their favor.
Yes,
My
sir.
lord, the first respondent has no absolute right over the suit scheduled property.
No, that has to be
But the
considered
trial,
only. That has to be considered only in trial,
please,
Yes.
my lord.
not a case for interference. Yes. Go ahead. This writ petition is filed by the plaintiff number 1 and 2 in OS number 13 of 2013 on the file of the additional senior civil judge and JMFC Gaddaballapura, challenging the order dated 15/2 2021. Please stop. The factual matters of the writ petition are that the plaintiffs are the petitioners are the plaintiff and have filed OS number 13 of 2013 on the file of the trial court seeking relief of declaration and declaration with consequential relief of permanent injunction. Full stop. In the said suit, the who are the impleading applicants actually? In the said suit, the written statement was filed, and thereafter, the impleading applicants / proposed defendant number 2 and 3 have filed an application under order 1 rule 10(2) read with 151 of CPC to be defendant number 2 and 3, and they have stated that they are the proper necessary parties to the above case, as the subject matter of the suit as the subject matter, they are also the involved. They are also have party to the sale agreement dated 11/7/2013. Full stop. As stated in para 3 of the affidavit in IA number in annexure D. The trial court, the said application was resisted by the plaintiff. The trial court, after considering the material and record, by order dated 15/2/2021, allowed the application and being agreed by the same, the plaintiffs have presented this writ petition. I heard Sri Nandish Kodal and a counsel appearing on behalf of Sri R.B. Sadashivappa and a counsel appearing for the petitioner. Sri Nandish Kodal and a counsel appearing for the petitioner submitted that the trial court has not properly appreciate the fact that the impleading applicants are not the necessary parties to the suit, and as such, allowing the said application by the trial court would cause multiplicity of proceedings in the case, and therefore is sought for interference of this court in the present writ petition. In the light of the submission made by the Learner Counsel appealing for the petitioner, I carefully considered the averments made in the affidavit in the application filed under Order 1 Route 10-2 with 151 number CPC. In para 3 of the said affidavit, impleading applicants have stated that the plaintiff an agreement was entered in between the parties involving the defendant number 2 and 3 on 11/7/2013, and as such they have to be heard in the matter. Having taken note of the statement made in the affidavit at annexure D, I am of the view that the trial court is justified in allowing the IA filed by the impleading applicants under Order 1 Route 10-2 of CPC, and accordingly writ petition is dismissed. Yes.
For the petitioner, my lord.
Yes.
For first respondent.
Yes. Number 2. Sorry.
I appear for respondent number 5 to 10. I filed a wakala today in the office.
Just a minute. You have filed power for?
Respondent number 5 to 10, my lords.
5 to 10, sir.
Yes, my lord.
Santosh Gogi. It is submitted by the Learner Counsel, Sri Santosh Gogi, that has filed power on behalf of the respondent number 5 to 10. And Sri K.V. Narasimhan, Learner Counsel appearing for Learner Counsel, submitted that he has filed power for respondent number 2. Registry is directed to verify the same and print the name of the Learner Counsel appearing for the aforementioned Learner Counsel appearing for the parties in the cause list and list this matter after 2 weeks. Yes. Yes, ma'am. The petitioner is permitted to take steps insofar as R13 is concerned.
Lord, 13 was already filed the wakalat, it seems, Lord. Lord, as per the cause, 14 and 15 are the children of 13, Lord.
They have to pay PF, sir. They have to pay PF. PF that they have.
Lord, 13 was appeared, it seems, Lord, because 14 and 15 are the minors of 13. Since she has filed the wakalat on behalf of her minors, therefore I think she might have filed the wakalat R13.
Represent Mandela. She is the
minor.
14, 15 are minors represented by 13, but 13 is not represented by.
Who is representing the R13?
13 is the
minors.
No, 14 and minor
13 is a mother. 13 is
yes,
a
mother of 14 and 15. She put the signature on behalf of minors. Therefore, I think she might have filed the wakalat.
14 and 15 are minors represented by 13. Who is representing the 13? Who represents R13? That's what I'm saying. Take process 13.
Please, me.
14 and 15 are minors.
Yes.
Yes.
Please.
Satishian. Yes, what is on? Yes. What is your case on Order 6, Rule 17? That cannot be done. That cannot be done. It's a settled. There's a judgment on the very same. No. Even that cannot be done. I think there's a judgment. You cannot change. You cannot modify. Yes. No. We have to go by. Even if you say that it may be allowed, I cannot. I have to go by law.
Submission. All will get affected. RTC. Wrongly, the petition and also wrongly mentioned as some exchange.
Not a case for it.
I produced the RTC.
Who are you before the trial? Plaintiff. You are?
I am for the defendant number 1 and 14. Remaining defendants are not applicable for this application.
Who?
I am only contesting this. I was pleading.
Just a minute. Go to plaintiff. Go to plaintiff. Page 70. So you want to amend the written statement. You are for a plaintiff. You have no objection. What about the remaining? What about the remaining defendants?
They are not finding an objection. All is fairly common.
Sorry. The short question involved in this petition is challenging the order dated 8 April 2021 by the Principal Civil Judge and JMFC at Chikka Ballapura with regard to dismissing the IA filed by the defendant under Order 6, Rule 17, read with Section 151 of CPC. After full stop, Lana counsel appearing for the petition, Satish N. Lana counsel appearing for the petitioner submitted that the defendants 1 and 2 have filed a written statement before the trial court. However, there is a yes, sir. 1 and 14. 1 and 14. 1 and 14 have filed written statement. However, there is a typographical error crept in so far as mentioning the appropriate survey number in the written statement, and the said fact was not properly appreciated by the trial court. Full stop. See, and accordingly is sought for interference of this court. Per contra, you have filed our for see A. Lurdu Mariappa Lana counsel H.S. Suresh. See H.S. Suresh. H.S. Suresh. H.S. Suresh Lana counsel appearing for the plaintiff submitted that, he has no objection to allow the writ petition, writ petition, and to set aside the order, set aside the impugned order passed by the trial court with regard to making correction of the appropriate survey number in the written statement. Extent of land in the survey, extent of land in the written statement. Having heard the Lana counsel appearing for the parties, undisputably suit is one for partition and separate possession. And in that way of the matter, though the trial court was justified in rejecting the application made by the defendant number 1 and 14 under Order 6, Rule 17, read with Section 151 of CPs to incorporate to amend the written statement, to modify the extent of land. However, taking into consideration the law 2015 judgment, taking into consideration to adjudicate a suit effectively, and in the ends of justice, the trial court ought to have allowed the application filed under Order 6 Rule 17 read with 1 to 51 of CPC. And in that view of the matter, I'm of the view that taking into consideration that the larger interest of the parties in the suit will be affected since the suit is one for partition, and accordingly the finding recorded by the trial court is set aside, and accordingly the repetition is allowed. 2015. No, I don't want. Why after? You said no objection, I said. That's all. Non-compliance, 2 weeks. 2 weeks time is granted to comply with the office objections. It's a council submission. Just a minute. What is that? With respect to above office objection. Twenty-second and 23rd page of Annexure B not forthcoming. Something council submission with respect to above office objection. 22nd and 23rd page in B, Annexure B. It is missing. 2 weeks time is granted to comply with the office objections. Same. 2 weeks time is granted to comply with the office objections. Yes.
My lords, I appear for the contesting respondent. Respondent number 8, my lords, is the village accountant. State may be directed to take notice, my lords. The matter may be posted, my lords, for because there's an interim order operating and the suit proceedings are stated.
AJ is R1 to R7 and R8 also. Then SCGP accept notice for respondent number 8. Come on. Is this matter for preliminary hearing it has to be posted?
For preliminary hearing, my lords, we will address the
21. Okay. This B group. 8 is 8 is government. You pay the PF. No, village accountant.
Village accountant.
Yes,
and anyways, the matter is with regard to court fee, my lords. Therefore, state is a necessary party either ways.
Very well. Yes. List this matter for B group after 2 weeks. Let us.
My lords, may request for a date, my lords.
Yes, sir. Interim order granted earlier. Interim order granted earlier, extended till next set of hearing. List after 2 weeks for 20.
Along with this, my lord, this is for declaration. There are 10 other suits which are tagged along with this. All the 11 suits are stayed, my lord. That's the reason, my lords. Unknown suit.
Yes, after 2 weeks. After 2 weeks, it will be taken.
Grateful.
Yes. Yes. 2 weeks time is granted to comply with your office objections. Same order. That you have to write. That you have to write. You comply with the same. No, you comply with the same, it will be taken. 1 week's time is granted to comply with the office objections. Yes, there are some other office objections are there. No, you comply with the office objection, you move it. Comply. 1 week's time is granted to comply with the office objection. Immediately you can move it. Same. 2 weeks time is granted to comply with the office. Yes. Number copies to be project page 90 certified copies. Then a council applying for the petitioner submitted that he has complied with the office objection. Registry shall verify the same. Yes, sir. Is this matter for admission for preliminary? Notice means preliminary. Notice not in orders. This matter for preliminary on Tuesday, if office objections are completed. Yes. Tuesday.
Serial number 15, Lord, I have offered
Lord,
I have offered an explanation for overruling the office objection.
Lord,
the proceedings that are challenged not before this.
What is the office objection?
That I have to file a separate application, not seeking permission of the court to file the writ petition.
Best available copy. No. Best available copies of annexure F and G has to be filed.
Those have been filed, Lord. Best subsequently.
Compromise has been arrived at between the parties before Lok Adalat. There is no appeal under law against the present writ petition filed, and challenge application is not necessary. Filing an application is not necessary.
Although they not officers raised an objection that I should file an application seeking permission of the court to file writ petition. The Lordship would see the matter not before the civil court.
Yes.
Came to be compromised before the Lok Adalat.
Yes, that was the award in Lok Adalat is assailed in this writ petition.
Compromise petition itself is challenged because I am not a party in respect of a property which is subject matter of the proceedings before the Honorable Supreme Court, which is still pending.
Office objection with regard to office objection number 2 is overruled. Registry is directed to verify the complaints of the office objection on office objection number 1 and list this matter for admission immediately thereafter. Yes, sir.
Could it be on Saturday? No,
Saturday. No, Saturday. Tuesday or Wednesday. Yes.
Number 16 is the petition.
So notice to R1. Furnish. Respond number 1 is dead.
Therefore, there will be no fallback against it. Only one respond in the petition.
Okay. You file a memo to that effect. So that yes. But you have to bring the legal representatives.
So very much.
Then a counsel appealing for the petition submitted that the respondent number 1 died, and accordingly he submitted that respondent number 1 full stop. This full stop. Accepting the submission made by the Lana counsel appealing for the petitioner, the issuance of notice to R1 does not arise. This matter after 2 weeks. Interim order granted earlier extended till next date.
Number 17 for the petitioner and the
yes.
The counsel submission by law. An office objection was raised as to why the Tahsildar is made a party as respondent number 10. This my lord, the refusal order appoints the Tahsildar as court commissioner, my lord, and I received notice from the Tahsildar's office at Section G. Hence, my lord, the Tahsildar
He cannot be.
made as a party.
He cannot be.
Please, my lord, because the notice was issued, I challenged.
He's a commissioner.
Please, my lord, I received the notice at Section G and
Yes, he sent a notice only pursuant to that he has received an order from the court. He cannot be arraigned as a party.
Since, my lord, I wanted to challenge that notice.
You can challenge. No, not challenge the notice. You have to challenge the order of appointing him.
I challenged both the orders, my lord.
Need not be. If challenge the appointing him as a court commissioner, that is it.
And since the notice was issued on 19th January and there was some urgency because they were conducting the survey, hence Tahsildar's office was also arranged.
Yes. 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 Respond number 1 and 2. You are for respond number? No, just wait. Details of copy to be served on government. Details of annexures to be stated. I think there are 4 objections that you have to complete. 4 objections. That they will complete. And a counsel appealing for the petitioner is permitted to comply with the office objection within 2 weeks.
My lord, there's some urgency. I will have it done.
Comply, I will take it.
Because my lord, survey notice.
Comply tomorrow, I will take it up day after tomorrow.
Please, ma'am. Number 18. You going to that case?
Yes. What is this? Order 2609. What is impugned, sir, in this? Annexure G.
Page 41.
Yes.
But more than 1 month after closure of evidence,
Hmm.
and when the matter was posted for argument,
Hmm.
plaintiff files the application for.
Yes. That has been allowed. That's the law.
No, not
That is only after the completion of the evidence, if the court has come to a conclusion that there is some ambiguity in the evidence, then the appointment of the commission. Yes.
Court has not felt that it is necessary.
No, that has accepted the application. That's the law. What do you mean? ILR 2007. ILR 2007. Yes, madam. ILR 2007. Karnataka 308 30299. 3029. 7 ILR 2007. Karnataka 3029. Yes, sir. Whenever there is ambiguity in the evidence, then the court can accept the application.
That is true, my lord. When there is court feels, my lord, when there is ambiguity, court can appoint a commissioner.
Yes, sir.
But plaintiff moving in application.
That is,
after the conclusion of
yes,
the
even
trial,
that is also,
but
that is.
it amounts to, my lord, collection of
Oh, it is there. Actually, anyway, it has followed actually. The last parallel is there, 56. Looking to the background of facts, ratio laid down by the Honorable High Court in ILR 2007 is applicable to the present case. It's a law. That's a law actually.
Right. Exactly similar case.
Very good. Noted. Purpose of the commissioner is to clarify any ambiguity.
But in this case, not IA filed by the party has been rejected. It has been upheld by the law.
Yes, sir.
Right, para 2, by the impugned order, the learned trial court has rejected the application filed by the plaintiff under order 2609, section 150 of CTC for appointment of commissioner for ascertaining the actual position of the site construction which, according to the plaintiff, was illegally being undertaken by the first defendant in the present injunction suit. Then my lord, next page. Exactly similar.
Yes, sir.
Lord, next page is law. First, Lord, top of the page, third line. Mandatory injunction for demolition of the unauthorized construction within the mandatory setback area on the southern, northern, and eastern side of Schedule B property, and for permanent injunction restraining the first defendant from putting up construction on Schedule B property, in violation of approved building plans and bylaws in setback areas, and also to direct the second respondent BPMP to remove the unauthorized construction made by the first defendant. This is the exact case in present case also.
Yes, sir.
Then, about 4-5 lines thereafter, the plaintiff and first.
Go to para 9. Go to para 9.
Para
9.
Just I will read this portion. The plaintiff and first defendant have reduced their evidence and closed their respective sites. Thereafter, the matter was posted for argument. At this stage, the plaintiff has filed the present application, praying to appoint a commissioner to find out whether Schedule B property is being constructed in accordance with the approved building plan, and if not, what are the violations made by the first defendant in construction of Schedule B property, and to report the same to the court.
Yes.
Already the contesting parties have reduced evidence in support of their case. The parties have to prove their case by reducing their evidence. On the
Yes.
other hand, the plaintiff has not shown reasonable grounds that the available evidence on record is insufficient for effective adjudication of the matter in controversy. Then there are having heard the learned counsel for the party, this court is satisfied that there is no error in the impugned order requiring interference by this court under Article 227 of the Constitution of India.
It depends upon the facts and circumstances of each case and the discretion of the learned trial court to appoint a commissioner. If the trial court feels any need of such clarification or assistance by an independent commissioner, otherwise the parties have to establish their respective case on the basis of the evidence led by them and on the appreciation of each other. Learned trial court is expected to record the findings and decide the suit in question. Such discretionary orders do not require any interference by this court. The judgment relied upon by the learned counsel for the petitioner plaintiff in the application rejecting the request for appointment of commissioner was upheld by this court. Observation that if there is no sufficient material, the trial court can appoint such commissioner does not have the present petitioner in any case, because the evidence in the present case has been recorded by the trial court and there is no finding that there was no sufficient material or evidence or record to decide the suit.
Yes.
But my first submission is this is totally believed and my lord kindly sees the element in this application. Application filed for appointment of commissioner. Lord kindly see page 37.
Yes, sir.
Affidavit filed in support of the IA.
Yes.
Lord second paragraph.
See, here the technical expert requirement is there.
Without appointment of a commissioner, it is very difficult to prove the contention raised by me in the plate. Any evidence will be insufficient to prove the case. That means he wants to collect evidence.
Yes.
Which is not permissible. Blood his sole affidavit.
Yes. You go to finding. Para 15, page 54. There's an encroachment. It's a common wall. He removes the damaged wall which is there in his boundary. So let there be a commissioner will be. It's correct actually.
But commissioner to inspect regarding violation of setback rules. But I have taken a contention. There is no such violation.
Yes, sir.
But which need not be proved by the commissioner.
Yes.
If there is not approved plan, I have to produce it and I have to prove it.
Yes, sir. Which is there in his boundary and he is not extending the sajja out of the boundary. And the court has completed. It's a discretionary that we cannot take.
But two more judgments which are relied by me before the court below.
Yes.
They are not reported.
Yes, sir. 2001.
But two orders passed into it.
Yes, correct. WP number 13560. Sorry.
You both may not order. Resolvable court and that it amounts to collection of it.
Yes, that cannot be done.
Yes.
Yes, that cannot be done. Correct.
And kindly consider, my lord, the stage at which the application is filed.
That is only after evidence. That's correct. Not prior to evidence.
No,
Yeah.
he produces not more than 10 documents.
Yes, sir.
Plaintiff.
Yes.
Then the matter was posted after closure of the evidence of the defendant.
Because the ring is a suit for mandatory injunction. Mandatory injunction is if any construction has been put up on the land belonging to the plaintiff, then he sought for even demolition also. Therefore, the court is say that requirement is. That's the facts. That's the facts. If it is a mere injunction suit, then appointment may not be acceptable. But in the present case, it's a mandatory injunction. That's what. Totally. Need not be. In this writ petition, petitioner has assailed the order dated 4th October 2021 passed by the Court of the 4th Additional Civil Judge and JMFC at Mysore in OS number 1386 of 2013. Succinctly, the facts of the case are that the plaintiff has filed OS number 1386 of 2013 on the file of the trial court, seeking the relief of mandatory injunction, directing the defendant to demolish the illegal construction made in the 3 feet width setback towards east of the plain scheduled property and in the western side setback of the property number 2613, 4th Cross, KG Koppal, Mysore, with and also sought for consequential relief of permanent injunction. The defendants entered appearance and filed a written statement. When the matter was after the completion of the evidence, the plaintiff has filed an application under Order 26 Rule 9 of CPC, seeking an order of appointment of the Assistant Executive Engineer, Mysore City Corporation, Mysuru, as Port Commissioner to inspect the plain scheduled property and to report regarding violation of setback rules by the defendant. The said application was resisted by the defendants / petitioner hearing. The trial court, after considering the material record by order dated 4th October 2021, allowed the said application and being agreed by the same, the defendant has preferred this writ petition. I have heard Sri Govindraj K. Lana Counsel appearing for the petitioner. Sri Govindraj Lana Counsel appearing for the petitioner submitted that the appointment of the commissioner by the trial court as per application number 12 is contrary to the factual aspects of the case, and he further submitted that the commissioner cannot be appointed for collection of evidence. He further contended that the said application was filed by the plaintiff after the completion of the evidence, which cannot be entertained, which ought not to have been entertained by the court, and accordingly he sought for interference of this court. In order to buttress his submissions, he relied upon the judgment of this court in the case of Anita Dev versus Sushila Bai, reported in LAWS within bracket KAR -2018-8-12, and submitted that the said judgment is fairly applicable to the factual aspects of the case, and therefore he contended that the impugned order passed by the trial court requires to be interfered in this writ petition. Having heard the Lana Counsel appearing for the petitioner, I have carefully considered the relief sought for by the plaintiff in the plaint, which reads as under. Page 28, relief. 28, but enter. In the background of the relief sought for by the petitioner, I have carefully considered the finding recorded by the trial court. Undisputably, the suit is filed for the relief of mandatory injunction and for consequential relief of permanent injunction. It is the case of the plaintiff that the suit scheduled property was acquired by the plaintiff as per the partition decree in OS number 311 of 1988, and the plaintiff is in possession of the suitable property. It is also forthcoming from the finding recorded by the trial court at para 15 of the impugned order that there is a common wall bifurcating both the properties of the plaintiff and the defendants. And if there is a separate wall exists and the plaintiff can remove the damaged wall which is there in his boundary, and therefore taking into consideration that both the plaintiff and defendants have contended before the trial court that alleging the encroachment made by either of the parties. Accordingly, the trial court accepted the application filed by the plaintiff in IA number 12. Taking into consideration the law declared by this court in ILR 2007, Karnataka 3029, I am of the view that the impugned order passed by the trial court is just and proper. We do not call for any interference in this petition. Accordingly, the petition is dismissed. Notice 19th. Notice delay of 46 days. Notice.
My lord, I appear for the petitioner. My lord, the petitioner is aggrieved by the orders as regards the objections on the maintainability, which was rejected by an order dated 12th July 2019, my lord. The contention of the
year number 19 is
that is as regards the dispensation of the order sheet. My lord, the lower court records have been already called for.
Lower court records, just a minute. Lower court records.
It is only the order sheet, my lord. I have filed an IA for dispensation of the order sheet. That is already on record before my lord. Therefore, nothing survives consideration for IA, my lord.
Okay.
As regards the IA, the matter may be taken up.
Yes, for preliminary next week.
My lord, subject to convenience, it's only a limited point. On the preliminary decree,
yes,
the petitioner was the plaintiff.
Yes.
And defendants were placed ex parte.
Yes.
There is a clear share that was allocated to the plaintiffs.
Yes.
Then subsequently, the defendants who were placed ex parte, they file an FTP.
Yes.
The contention of the petitioner is this, my lord, for the consideration. When there is a no specific share which has been there in the preliminary decree, the defendants cannot, in a straitjacket formula, by avoiding section 96 and the appeal or the review, straight away go to FTP,
yes,
and maintain the petition.
So according to that cannot be that is that
Please, my lord.
FTP itself is not maintainable.
Please, my lord. The settled position of law is
since no share has been assigned to
please. That is the only point for consideration before the
petitioners in FDP.
Please, my lord. And when
the
law provides,
what is the law point?
My lord, the impugned order is at
What is the law
my lord would appreciate.
What is the law on the point? Actually?
The law is my lord, EAR 1966 Allahabad very clearly says the courts of law cannot go behind the decree and have to take further steps on the basis of decree already passed.
Yes, correct.
Consequently, if the preliminary decree passed in the partition suit does not contain any declaration as to the rights of the defendants, their application for partition or separation of their share shall not be maintainable till they have the preliminary decree suitably modified. But once the preliminary decree contains a declaration as to the defendant share, they can, even after the passing of preliminary decree, take steps for the separation of their shares. This is the law, my lord. In fact, my lord would appreciate the order dated of this honorable court when it had come for the preliminary hearing, my lord. On 14th August 2019, my lord has the order sheet. 14th August 2019.
One minute.
Please.
Order sheet dated?
The coordinate bench order of 14th August 2019.
14 August.
The order sheet of this court, my lord. My lord, the finding of this court is.
Yes, just 1 minute.
Please.
14th August. 1 minute.
My lord has
proceedings
issue emergent notice, call for LCR.
Share is not demarcated in the preliminary decree for 40. Petition cannot maintain FDP wider. So and so. Yes, sir.
Please, my lord. This is the only contention. This is the point for consideration before this honorable court. Since it is a settled position of law that defendant whose specific share is not demarcated in preliminary decree for partition and separate possession cannot make.
So in a suit for partition, preliminary decree is passed. No share has been given to one of the party. Thereafter, he preferred FDP. The FDP is maintainable? No share has been assigned to him.
Lord, may I make a mention, Lord? I'm for the
1 minute,
respondent.
1 minute.
I'm the respondent. Lord.
1 minute, sir. 1 minute.
Please.
Be considered on that before
So according to FDP is maintainable.
the FDP, then would your lordship would proceed.
Now, whether the FDP is maintainable,
He would then have to proceed, leaving aside one portion and then probably.
no property was assigned to that.
Then he would not be.
Because it cannot go beyond.
They can't go beyond.
Can't be
Even
beyond.
if they are not parties, they are entitled to it.
I know, that's true. Even parties may be added also.
Please.
Yes.
I agree on that proposition. The only point is this, my lord. When a particular thing has to be done in a particular way, it has to be done in that process. They cannot straight away come, being ex parte today, maintain
any other judgment by on the very same point except Allahabad High Court?
My lord, this is coming up for the first time. Therefore, Allahabad will directly help me, and it has a persuasive value for consideration, and the law will be laid, my lord.
Now get the judgment one which is opposed to you also better.
This is the closest, my lord.
Cases will be appreciated. Huh?
And one more citation
Yes.
of 2009 SCC Online Allahabad 482. My lord, in this, it must have determined the rights of parties with regard to all or any of the matters in controversy of the suit. There must be a formal expression of such adjudication. The rights of each parties has to be determined, and such determination is conclusive in nature. The court below has directed the final decree be prepared, which amounts to a formal expression of such adjudication. In light of the aforesaid, this court is of the opinion that the order of the trial court is a decree within section 2.2 of the CPC and consequently appealable. Therefore, under section 96 as well as 97, there is an appeal which is provided. And whatever, and it's a continuation of the rights of the parties.
Correct.
There is no bar on that. I am in agreement with that. But when they were placed ex parte in a preliminary decree, the maintainability of the FTP is questionable when the clear share has not been determined in the preliminary decree, my lord.
Very good.
My lord would appreciate. That's it.
Please.
2000. Just repeat. 2009.
My lord, 2009 SCC Online Allahabad 482.
Online Allahabad
482, my lord.
482. Yes.
My lord,
Yes, Mr. Shripad.
Please, my lord, kindly take page number 24, my lord.
Yes,
Page
24.
24, paragraph 9, my lord.
24.
Paragraph 9 of the order.
9, yes, sir.
May I read, my lord?
Yes, sir.
While giving answer to point number 1, this court comes to the conclusion that the plaintiffs have proved that the suit scheduled property is their ancestral joint family property, and they are in joint possession and enjoyment of the same. Admittedly, the plaintiff and defendants are the legal heirs of late Rudrappa. The plaintiff number 1 being the wife of late Rudrappa, the plaintiff number 2 as well as the defendants number 1, 2, 3, who are the respondents before this honorable court, Lord. being the children of late Rudrappa, is entitled to equal share in the joint family property. Hence, this court comes to the conclusion that the plaintiffs number 1 and 2 and the defendant number 1, 2, 3 each entitled to 1/5 equal share in the suit schedule property. Lord, therefore,
according to 1/5 share is granted.
1/5 share to petitioners, they are granted. Lord, 3/5 share is, Lord, granted under this finding. Lord, this is not challenged, Lord. And then, Lord, they filed a FDP proceedings. Lord, that is suppressed before this honorable court.
1/5 share each.
It's there in Annexure A. I take an objection. It's already filed in Annexure A. It's already there. That FTP also I have mentioned in part of my grounds.
Correct.
I'm sorry.
Just 1 minute, sir.
Please, none argument, sir.
1/5 share is granted.
1/5 share is granted. Please.
Then the
this is observed by the FDP court also in the impugned order.
What is the ranking of the parties in FDP? Where is the OS order actually?
Well, Lord, OS decree is at page number 25. Page 25 is the operative portion.
FDP is preferred by the Shivacharya Alata.
We were the defendants, Lord.
Yes, 1/5 share they are claiming. Yes.
They are claiming 1/5.
FDP is maintainable.
Please, mate. Lord, one more submission is kindly come to page 15, my Lord.
50.
Please. Paragraph 3.
50. 1 minute. 50 is only hearing.
15.
Yes, sir.
Paragraph 3. May I read, no?
As per the judgment.
The judgment and decree on 4/12/2010, the respondents have filed. Lord, this the respondents means the petitioners herein. Lord filed FDP 11 of 2010 against the petitioners for survey and demarcation of the petition scheduled properties before this honorable court, and to allow 2/5 share to them. In the said FDP proceedings, the honorable court has appointed court commissioner with the help of surveyor for survey and demarcation of the petition scheduled premises, and to allow 2/5 share, separate share to them. The court commissioner has issued notice and fixed the survey to 27/2/2007, but the court commissioner is not yet surveyed the suit scheduled properties. On 4/3/2007, the petitioners, Lord, some correction, the respondents here, the petitioners herein filed a memo before the court stating that FDP proceedings in FDP 11 of 2010 may be dismissed for the reasons best known. Lord, they themselves filed FDP proceedings. They withdrew the FDP proceeding. Assuming, Lord, the FDP proceedings continued, I could have contested the very same FDP proceeding. My shares could have been allotted by the very same court. That is not done. They withdrew that is not mentioned, though it is a part of record, that is not mentioned in the writ petition.
Yes.
My share is already determined by the court by way of finding, and that is not challenged. And having not challenged under section, Lord, it is not their case that entire suit scheduled property belongs to them. Their share is 1/5. Lord, if their share is decided, they should not, they have no right over my share. Lord, to segregate my share, I have filed FDP proceeding, which is maintainable. That is what observed by the trial. This is all.
My Lord, by way of rejoinder reply, my Lord would appreciate Annexure B at page number.
Whether the share has been given to them.
I'm just answering that as a rejoinder, my Lord.
Whether share has been given to them.
My Lord, the operative portion, my Lord, in page 25, please see the order. The suit of
number
the
1 and 2 is entitled for 1/5 share each in the social property by way of partition by memo. Yes. That is whatever. That is the operative portion. If you go to para 9.
Please, my Lord.
Hence, this court has come to a conclusion that plaintiff 1 and 2 and the defendant 1 to 3 each entitled for 1/5.
Lord, harmonious interpretation has to be, Lord, considered. Lord, yes, there is a share granted.
Yes,
my Lord, even
share is granted under finding number, Lord, finding number 2, Lord.
This
my Lord, my Lord, one submission at page 42, paragraph number 14.
42, yes.
The order that is impugned. Therefore, this court, while passing the judgment, has declared the rights of the defendants and also in the judgment, Of course, said declaration is not depicted in the operative portion of the judgment and decree. However, harmonious reading of judgment and decree clearly shows that there is declaration of rights of present petitioners also in the judgment. The petitioners who were defendants in original suit OS 3 of 2009 have filed the present petition seeking to draw the final decree to ascertain 3/5 share together in the plain schedule properties. Therefore, the petition filed by the petitioners is very well maintainable. The objection raised by the respondents with respect to maintainability of the petition is not well founded. My lord, this is what I am challenging. My point is this, my lord. There is no
this
formal
must have been challenged before the under section 96, not before the FDP proceeding. He must have challenged this finding in section 96 appeal.
Appeal, yes.
Now he is precluded, Lord.
My lord, my lord, my contention is this. There is nothing that precludes the respondents from going on an appeal. And
yes, why they have to go?
My lord, they have been
They are
already
not aggrieved. They are not aggrieved.
My lord, on the
No, their share has been already determined.
But my lord, in the formal expression, it is not there. And that is my contention under 2 Rule 2. The decree has to be challenged. They cannot, after being placed ex parte, they cannot file an FTP and assume that this is the share that is demarcated. What if there are other legal representatives? They file an application tomorrow. How can on an assumption an FTP can be drawn when there is no formal expression in a preliminary decree?
That is not the case, Lord. That is not their case. Please.
No, wait.
The law provides clearly.
Sorry. No. Sorry. This writ petition is filed by the respondents in FDP number 11 of 2017, challenging the order dated 12th July 2019 on maintainability of the petition. Brief facts for the adjudication of this writ petition are that the respondents, the petitions herein have filed OS number 3 of 2019, seeking relief of partition and a separate possession in respect of their share in the suit schedule properties. The trial court by judgment and decree dated 20th October in OS number 3 of the trial court by judgment and decree dated 20th October 2010, decree the suit holding that the plaintiff number 1 and 2 are entitled for 1/5 share each in the suit schedule property by way of partition by metes and bounds. Full stop. The defendants in OS number 3 of 2009 have filed FDP number 11 of 2017 under order 20 Rule 18 read with section 54 of CPC, seeking final decree by allotting 3/5 share to them as per the preliminary decree passed in OS number 3 of 2009. In the said FDP proceeding, in the said final decree proceedings, respondents have raised objection with regard to maintainability of the petition. The trial court, after considering the material in the record by its order dated 12th July 2019, dismissed, rejected the objection raised by the respondents / petitioners hearing. Full stop. Being agreed by the impugned order dated 12th July 2019, the respondents in FDP number 11 of 2017 have presented this petition. I heard Mr. Shavant Arya Thanda, Lana Council appearing for the petitioner, and Sri S.R. Sri Prasad for Lana Council appearing for the respondents. Sri Shavant Arya Thanda, Lana Council appearing for the petitioner, contended that the trial court in OS number 3 of 2009 has not allotted any share in so far as the petitioners in FDP number 11 of 2017 is concerned, and therefore the final decree proceedings initiated by the defendants in OS number 3 of 2009 is not maintainable Accordingly, he submitted that the finding recorded by the trial court is contrary to the law declared in the case of Srimati Bittan Devi and others versus Rudra Sen and others, reported in AIR 1966, Allahabad 601.
My lords, in page 8, para 16, that
Per contra, SR Sri Prasad Lana counsel appearing for the respondent number 1 to 3. Invited the attention of the court to the para 9 of the judgment and decree dated 20th October 2010 in OS number 3 of 2009. And submitted that though in the operative portion of the order, the allotment of share has not been made insofar as the defendants are concerned. However, while answering the point number 2, the trial court has held that the defendant number 1, 2, 3 are entitled for 1/5 plaintiff 1 and 2 and defendant number 1 to 3 each entitled for 1/5 share in the suit property. And accordingly, he submitted that the final decree proceedings initiated by the defendant is maintainable. Having heard the Lana counsel appearing for the parties, the core questions to be answered in this writ petition is whether there is any allotment of share has been made insofar as the petitions in FDP number 11 of 2017. In order to ascertain the same, it is useful to deduce the para 9 of the judgment and decree in OS number 3 of 2009, which reads as under page 24. Type. Underline, emphasize on it, last line. Hence, this court comes to the conclusion that plaintiff number 1 and 2 is owned. That I have underlined. Emphasis applied. Taking into consideration in the finding recorded by the trial court that the plaintiffs number 1 and 2 and defendants number 1 to 3 are entitled for 1/5 equal share. I am of the opinion that the FTP proceedings in 11 of 2017 is maintainable. Accordingly, I do not find any perversity in the order dated 12th July 2019 passed by the trial court. Accordingly, the petition is dismissed. Yes.
Grateful.
For bringing a decision R1 issue notice on IA 21. Number 22.
My lord, I appear for the petitioner in this matter, my lord.
Yes, sir.
I appear for my lord. One more writ petition, my lord. WP 2148 of 2022 that has to be posted for preliminary hearing, my lord. That may kindly be posted along with 2148 of 2022.
Tag along, connect along with so and so. WP number 2148 of 21.
My lord, in this matter, my lord, date may be fixed, my lord. My lord,
this two writ petition and next week on date. 9th.
Acho.
9th, yes.
Madam, it is appear for the petitioner, my lord.
Yes, sir.
Seek 2 weeks time, my lord, to file no objections.
No. What is the case actually?
Case is like I sought for additional evidence, my lord, to produce certain documents.
Now, what is the impugned order? What is the impugned order?
Impugned order is that my applications were rejected.
Which is that actually? Order.
I just take a lordship for that. Annexure J, my lord.
Annexure G. Yes. Please go to Annexure G. Yes, sir.
in page 50, my lord. Though IA3 and IA5 provisions are wrong, but that does not disqualify the application. The contention of the plaintiff is that after his cross-examination, when he searched Almira, he found Xerox copy of his agricultural loan account, loan documents.
Go to page 50, sir. Go to page 50.
50 is, I'm reading that.
Yes, sir. Though IA3 and 5 provisions
are wrong,
that does not disqualify
the application. Yes, the contention of the plaintiff is that after his cross-examination, when he searched in Almira, he found Xerox copy of his agricultural loan document, which certifies the loan amount disbursed by him to him by way of cash from the Citygate Bank on 13/1/2014. But during his cross-examination, I asked to court question that whether you have produced any document to establish that you possess 28 lakhs as on date of Exhibit P1. He has answered that I do not have any such document. Subsequently, after his cross-examination, he has filed the above IAS to permit him to produce said document by reopening the case to lead further evidence. Here it is to be noted that the plaintiff is fully aware of the court question and has answered to it, and in his reasons in the affidavit, he has not made sufficient ground for the delay in producing the particular document at the earlier stage. Hence, at this stage, I find no genuine cause. My lord would say that these documents are related to bank documents. It's not that they're personal documents which have not been cooked, could have been cooked up or anything.
Yes.
These are sealed and signed by the bank officer, and they have given these documents. I don't see what is the difficulty there.
Yes.
And there's lots of could say that this is a fifth case where it should be allowed and they be permitted to lead further evidence. The huge amount of 30 lakhs that has been given to the sale.
Yes, sir.
And they have produced the bank document. It is not any other document which is questionable.
Yes, sir.
But in this case, as my brother conduct rightly pointed out, that the court has asked the question and he has said he has no documents. Lordship may kindly take.
But these are all the document in which he is referring to is the document relating to the bank details.
Bank details, bank transactions.
What is pleading, and moreover, in the cross-examination, it is elicited. How he has paid. He has went to the page 2 of my statement of objection.
No, what is sought to produce is the statement of account.
Yes, Your Lordship. In this regard,
it's a statement of account. It may be produced.
Your Lordship, in this context, I have cross-examined. It is not that.
Well, he might have stated, I do not have any document. But it will. But
I produced the evidence cross-examination.
no, he might have stated. He might have stated that it doesn't have any document.
He does not have anything. He directly paid.
But
even in his pleading, the Lordship, in this pleading, he says he has not mentioned anything about.
But now he sought to produce. See, it's not some documents in which it is only the bank details.
Yes, please. As for bank details.
Yes.
It is not in pleadings. This is not the pleadings of his case that he has got the amount. The evidence I have elicited. Simply, the defendant came to his office and he immediately gave the cash. That is his evidence I have elicited. And moreover, after this court specific question that he does not have any document, if this is allowed, then what the evidence has been elicited by the court will be diluted. Now, if the question asked and the answer deposed, it will be diluted by bringing out this evidence that he has got a copy.
Yes. Now he sought to produce the said document.
That is, Your Lordship. After
you might have stated that I do not have any such document in the cross-examination. But thereafter,
it will dilute the evidence, and it is a specific question.
It is only a statement of account that may be allowed.
No, it is the specific question of the court that whether he has got any document to show. He says that he does not have, and the court specific question is answered in negative. Whether he is permitted to print a document and in contrary to what he has answered before the court, that is the one thing Your Lordship has to answer. If that Your Lordship says that it can be, then each and every evidence in whatever it is being elicited.
No, it is a document which is, I think, the bank statement issued by the Syndicate bank.
The other,
It is not a document in which it has been so far as created by on his own or something else. It is only a bank statement you want to produce. Yes. No, you stated this already. It is in your statement that you have stated. In your statement you have produced R1.
Yes.
No, that's what I read it actually. R1 you have stated that you have produced so and so. And
cross-examination.
Yes, cross-examination is said. Whether you have produced any document to establish that you have purchased so and so. I do not have any such document.
That is
After the conclusion of the
question,
question, yes.
That is the fourth question. I have asked certain question. I may be permitted to read what I have asked question and what he has answered to that. I came in accordance with the, this is the cross-examination. I came in accordance with the defendant proof one Procedural and he said Procedural informing that he is doing real estate business and told defendant are selling the property question. And asked me to
Anyway, it is open for you to cross-examine on this.
Further cross-examination is always available to him, my lord.
It is open for you to cross-examine on the said document. You can pose any question which
moreover, similar application, now he has challenged, similar application, again he has filed before the trial court.
Similar.
What similar?
Have you filed?
After rejecting
The first time it was rejected because the provisions are not clear, so therefore we filed a fresh application.
The second time,
It's not that it was discussed on merits.
What happened to this, that application?
I have filed my objection, but he has challenged this order. The worship I may be permitted to bring that
Told him. Then a counsel appearing for the respondent submitted that.
because he can't do things at the same time.
Pursuant to the impugned order dated 24/9/2020, the petitioner herein has filed identical application before the trial court, and same is pending consideration of the same. The counsel appearing for the respondent seeks 1 week's time to produce the same. Yes, parties are at liberty to produce the same list after 2 weeks. Yes.
The interim order will continue.
Interim order granted earlier extended till next set of year. Modified.
May it please your lordship, I appeal for the petitioner in this matter and for the respondent number 1 in the connected matter, my lord.
Yes.
So in
just a minute. Modify. Have you filed objection, ma'am, for modification?
My lord, they have to file. We have filed the IA for modification.
They have filed. Either you have filed objection.
I have filed the application.
When you have filed? 17?
That's the connected matter.
Yes. Recall the order dated. You have to file objection. You have to file objection to the IA 1 of 20, IA 2 of 22.
Yes, that's in the connected matter, my lord, and they
Yes,
have
you file it,
undertaken.
you file it.
And they
You
have
file it.
undertaken to
And a
file
counsel appearing for the
objections
respondent.
in this matter.
Respondent in 17947 of 21 seeks 2 weeks time to file objection to IA 2 of 22. List interim order granted earlier extended till next set of hearing. In 24.
In both matters. In 24 also, yes.
Yes, in 24 also.
My lord,
Interim order-
another submission. In
Yes.
serial number 24, they have undertaken to file objections to the IA for modification.
He said he has already filed.
I have not received a copy.
Yes. Have you, sir? Oh, you are not filed. First matter only 1307. Sri Bipin Negre on account of the respondent number 1 seeks 1 week's time to file objection. 2 IA 1 of 21. List after 2 weeks. Yes.
Please. Interim orders may be extended in both.
Yes. Interim order granted extended till next public. Yes. Both the matters. Yes, ma'am. Yes. Correct.
My lord, I'm so sorry. I'm very sorry, my lord. I'm just not able to hear my learned friend. Please permit me in the afternoon. I'll come there physically, my lord. I'm simply not able to hear that.
1 minute, sir. 1 minute.
I appear for the caveator council. I'm sorry.
1 minute, sir.
Please.
Can you hear now, sir?
Not really, my lord. I'm so sorry.
Can you hear me now?
I'm much better, but it's still not very clear. If your lordship permit me around maybe 3:30, your lordship has some 2:30 matter. After that, I can come, my lord. I'm sorry.
I know I have some tutor or any other day.
Your Lordship, the difficulty is it's posted for judgment day after tomorrow.
No, my lord. I'm told it's on 8th.
8th.
I'm told the matter is on 8th. Your lordship may have it on Saturday also, my lord. I will come. I'm sorry. I was not expecting to be a busy appearance today, but I'm sorry.
Your Lordship, now I'm quite audible. So
It's not. He's not audible.
Mr. Nandakumar, now I'm audible.
No, he's not able to get it.
Would your lordship want me to come there, my lord? After the 2:30 matters, I can come, or Saturday, I'll leave it to your lordship.
No, I'll
Take a chance at.
I'll take a chance in the afternoon.
Yes, better. Take a
Perhaps
chance.
around
Better.
3:30 or so, my lord. I'll be there. I'm very grateful.
Yes. Take a chance at 3:30. Pass over.
Great.
Putting. Supinal ಏನಿಲ್ಲ. No exam. No representation on behalf of the petitioner. In order to provide an opportunity to the petitioner, let this matter on Tuesday. Yes. Yes.
In pursuance of the order, my lord, my suit, OS number 746 of 21, for specific performance is decreed in my favor. And
What is sought to be challenged in this order 1 rule 10?
Yes, my lord. The fact case, my lord.
Annexure H. Just go to annexure H.
My lord, I being the agreement holder, my lord, executed by all the respondents. Filed a suit for specific performance. The suit of the specific performance is pending before.
You are an agreement holder.
Yes, my lord.
Yes.
Suppressing the material fact, my lord, all of the respondents have filed, appears to have filed OS number 7046 of 2011.
Yes. 7046 of 2011.
Yes.
Is filed by the parties that they are all the respondents.
All the respondents. The agreement was also executed by all the respondents in my favor and restored the self-reservation. I filed a suit for specific performance. In the meantime, without bringing to the notice of the court.
What is your suit actually?
My suit for specific performance.
Suit OS?
OS number 7046.
7?
2011.
7046.
Yes.
Oh, that's correct. It is filed by you for seeking relief of specific performance. Yes. What is the suit filed by them?
Yeah, they filed a suit for partition.
Partition, which is that OS?
OS
4032.
4032.
Yes. What happened in 4032?
They got compromised. And the decree came to pass.
Yes.
Allotting the share.
What happened in your suit?
My suit is decreed.
Decreed in your favor.
Yes. I placed the.
Now you wanted to implead in FDP.
In the FDP proceedings, I came to know that the parties are entered into compromise and the decree came to pass. And the FDP proceedings came to be filed. A notice was issued, and there I made an application. The implead me because my interest is also to be safeguarded.
Yes.
And if the third party's interest is came into picture in the FDP proceeding,
But the trial court has come to a conclusion that instead of impleading in the FDP proceedings, better you execute the judgment and decree in 7046. That's what. However, it's made clear that you propose go to page 87.
But in the meantime, the FDP proceedings, third party is purchased the property. My suit is decreed. And therefore, when my interest has been safeguarded.
Correct. Anyway, it is already sold.
No. The property is not being sold. The commissioner is appointed. The commissioner is also appointed. And the sale was not confirmed. And then now the trial court has now proceeded to reappoint the commissioner. The commissioner court was not, the fee was not paid. And therefore, I'll place apply for the certified copies of the FDP proceedings of the order sheet. And therefore, I wanted to bring it to your lordship's notice that what has happened. Till date, no proceedings has happened, and third party's interest is not created.
Yes.
And therefore, all the parties before the lordships as a respondent.
What prevented you from filing the execution petition?
When the application was filed, my lord, the suit was pending for arguments.
Yes. Sorry. Issue emergent notice to the respondent. You are appealing for R2, yeah? R2. Mr. KB Lokanath, one counsel appealing for the respondent KV8. KV8 to accept notice for R2. All further proceedings in FDP number 46 of 2014 on the file of the 20th Additional City Civil Judge at Bengaluru is stayed. Yes, let us read it.
My lord, for the petitioner, my lords, in serial number 28, my lords, I have received NOC, my lords. This is a matter on NOC. I will request time till Tuesday, my lords. I will argue this matter.
At the request made by the Lana Council appeal for the petitioner, is this petition after 2 weeks?
My lords, 8th, my lords, date may be given, my lord. I'll argue it. I think 8th or 9th, 10th.
11th it will be.
Please.
Yes. Rahul,
yeah. I appear for the petitioner in this matter, Your Lordship.
Yes. 29.
Yes, Your Lordship. In this petition, I'm seeking to set aside the order dated 1810 passed in a joint memo, Your Lordship.
A joint memo.
Yes, Your Lordship. The petitioner is the plaintiff number 2.
Who has filed the joint memo?
The plaintiff number 1 and the defendant, Your Lordship. The plaintiff number 2 is the petitioner before this honorable court. Your Lordship, briefly, the facts are the respondent number 2, that is the plaintiff number 1 before the trial court, and the petitioner. They both file a suit for declaration and possession, Your Lordship. And also, the sale deed dated 3rd September 2013 is invalid, illegal, and not binding. Impugned order is at page number 36, Your Lordship.
Yes.
37, the order starts.
Yes.
Briefly, the case is, Your Lordship.
So there are 2 plaintiffs.
Yes, Your Lordship. So 2 plaintiffs.
You are the plaintiff number 1.
Plaintiff number 2. No,
plaintiff number 1 and the defendant have settled the dispute.
Yes, that is the say of the defendant, that he has settled the matter with the plaintiff number 1 and he files a joint memo. Now, Your Lordship, we have issued an NOC to the plaintiff number 1 during the pendency of the suit. He has not engaged any services of the advocate and he did not come before the trial court. Now, Your Lordship, all of a sudden, the defendant will file a joint memo stating he has settled the matter with the plaintiff number 1 and he has obtained confirmation deeds to that effect.
Correct.
And he places a joint memo. The plaintiff number 1 has not come before the court, Your Lordship. We have disputed this.
Why do you worry about him?
We have disputed the signature, Your Lordship.
Anyway, you continue proceedings as a plaintiff number 2.
Your Lordship, the entire scheduled property belongs to me. To that effect, I have filed an amendment application also, and the amendment application has been allowed. The entire suit schedule property belongs to me.
Then the cause of action in the suit.
Yes, Your Lordship.
Is different. 537 up to 14 is changed. I think there is no, the error committed by the trial court. Go to para 9. So the confirmation deed has been made in favor of the defendants.
I am
by the plaintiff number 1. Yes.
But I am disputing the confirmation deed, and that is that is a fraudulent.
Not indifferent.
I am disputing this.
Not in the present suit.
No, Your Lordship, the entire schedule property belongs to me. If Your Lordship may kindly turn to my amendment application, I have produced at page number.
Whether any order has been passed by the court on your amendment application?
Amendment application has been allowed, Your Lordship. Page number 48, Your Lordship.
Yes, sir. Yes, sir. It is still pending. That's what
Your Lordship, if that is the case, I'll kindly check that and get back. Your Lordship.
No. Not cannot be. It cannot be done. But that for limited time.
As far as my information, it was allowed.
Yes, that's right.
I'll produce the order sheet, Your Lordship.
Plaintiff number 1 and the defendant have insofar settled their dispute. Pursuant to the confirmation deed. Yes. Yes.
The plaintiff has not come before it is a forged signature, Your Lordship. I am disputing, and there is no signature of the plaintiff has not come before the court. There is no signature on the order sheet also.
You proceed with the suit.
In order to, Your Lordship, in order to proceed, the entire suit schedule property belongs to me. That is my contention in.
Yes, amended the suit. There are two, one time memo, another application for R1 to 10. Both application. So yes, then the order of the court. Yes, substituted country number 1 as a different number 2.
Different number 2.
Yeah.
What happened to that application?
Amendment application is still pending. That R1 to 10 application
allowed. Now you have been arraigned as a different number 2. And then suit will continue.
There are 3 of the plaintiff, in this para, he has application of plaintiff number 1 is absolute owner of the suit schedule property.
Anyway, you have transposed him as a different number 2.
Your Lordship, plaintiff number 1 is the.
But he has got the entire 2 acres 29 quotas. I requested more amount, Your Honor. In fact, I offered you to settle the matter.
No, just a minute.
Your Lordship may permit me.
Anyway, you have transported him as a different number 2 in OS.
Yes, Your Lordship. Yes, Your Lordship.
Continue the proceedings.
Now, Your Lordship, in view of this order,
the relief sought for in the OS survives.
In view of this order, the entire schedule property belongs to me. Your Lordship may kindly permit me for 5 minutes.
Belongs to me. It is subject to the result of the suit.
If the suit is decreed, Your Lordship, again I will have to file one more declaration suit for the property belonging to plaintiff number 1.
Anyway, you are transported as a different number 2. You continue the proceedings.
Your Lordship, if Your Lordship may kindly turn to page number 51, Your Lordship.
Sorry.
Your Lordship, page number 51.
Not a case for interference.
If the suit, Your Lordship may kindly permit me, if the suit is decreed, Your Lordship, I will have to again file a declaration for plaintiff number 1 share against the defendant.
That's why your amendment application is pending. You pursue your amendment application.
If Your Lordship, in that case, Your Lordship, let this be stayed till the amendment application is disposed according to law. If my amendment application is dismissed, Your Lordship, then this order holds good. If my amendment application is allowed, then there is no point in the suit itself, Your Lordship. If my suit is decreed, for the plaintiff number 1 share, again I will have to file one more declaration suit.
Yes.
Your Lordship may kindly grant me 2 days time. I'll pursue the order sheet and produce it before this honorable court, if the amendment application is allowed or not. As per my instructions, it is allowed, Your Lordship. I'll just verify it once again and come before this honorable court.
Third. This writ petition is filed by the plaintiff number 2, challenging the order dated 18/10/2021, passed by the Fourth Additional Senior Civil Judge, Bengaluru Rural District. on the joint memo filed by the plaintiff number 1 and defendant. Brief facts are that the plaintiff number 1 and 2 have filed a suit for declaration to declare that the plaintiffs are the absolute owner in possession of the suit schedule property and the suit was contested on on service of notice the respondent entered appearance and filed written statement denying the averments made in the written statement. In the meanwhile, the plaintiff number 1 and defendant have jointly filed a memo stating that the plaintiff number 1 had executed registered confirmation deed dated 23/6/2016 in favor of the defendant by confirming the earlier registered sale deed dated 3/9/2013 and accordingly sought for dismissal of the suit in respect of the plaintiff number 1. Full stop. The said memo was opposed by the plaintiff number 2. Full stop. The trial court, after considering the material and record by order dated 18/10/2021, passed the impugned order dated the impugned order holding that the joint memo filed by the plaintiff number 1 and the defendant is just and proper and accordingly dismissed the suit as against the first plaintiff. Being agreed by the same, the second plaintiff has preferred this writ petition. I have heard Sri Rahul is ready and a counsel appearing for
Vivek N, Your Lordship. Vivek N. N.
I have heard Sri Vivek N and a counsel appearing on behalf of the Rahul is ready for the petitioner and Sri P.B. Raju and P.B. Raju and a counsel appearing for the caveator respondent. And along with Sri K.N. Ganesh and a counsel appearing for the respondent hearing. Full stop. Rahul S. Reddy and a counsel appearing for the petitioner contended that during the pendency of the suit, the plaintiff number 1 and the defendant have colluded each other, and accordingly, the confirmation deed came to be executed on 23/6/2016, and therefore, the plaintiff number 2 is the owner in possession of the entire extent of land, and in the event the plaintiff number and in the event the joint memo is accepted, the right of the plaintiff number 2 would be prejudiced, and accordingly he sought for interference of this court. Per contra, Mr. Sri K.N. Ganesh and counsel appearing for the respondent, invited the attention of the court to the finding recorded by the trial court at para 9 of the judgment. He further contended that, the plaintiff number 2 has filed an application under order 1 rule 10 clause 2 read with section 151 of CPC to transpose the plaintiff number 1 as defendant number 2, and the said IA came to be allowed, and the plaintiff number 1 has been arraigned as defendant number 2. And in that way of the matter, he submitted that there is no infirmity in the impugned order passed by the trial court. Accordingly, sought for dismissal of the writ petition. Having heard the learned counsel appearing for the parties, it is undisputed fact that the suit for declaration has been filed by the plaintiff number 1 and 2 together against the defendant, and during the pendency of the suit, plaintiff number 1 and defendant have settled their dispute, and pursuant to the same, the plaintiff number 1 executed registered confirmation deed dated 23/6/2016 in favor of the defendant comma, by confirming the earlier registered sale deed dated 3/9/2013, and accordingly, 13, full stop. And accordingly, the trial court, having taken note of the fact that the relief sought for by the plaintiff number 1 has become odious, and accordingly permitted and accordingly accepted the joint memo filed by the plaintiff number 1 and the defendant. Full stop. I've also noticed in the writ papers that as per annexure F, the plaintiff number 2 has filed an application to implead to transpose the plaintiff number 1 as defendant number 2, and the said application has been allowed by the trial court. In that view of the matter, I do not find any error committed by the trial court, accepting the joint memo filed by the plaintiff number 1 and the defendant. Accordingly, the petition is dismissed.
Your Lordship, one submission. A finding may be given, Your Lordship. If in case I succeed in the suit, the orders on the joint memo may not
anyway,
come
you have
in
transposed him as a defendant number 2.
Yes, Your Lordship.
Yes.
If my amendment application is allowed and the suit is dictated, Your Lordship, I'll have to file one
That
more
is
suit for
nothing to do with the joint memo.
Next, Swami, if the joint memo,
Next
orders on the joint memo may not come in the way.
You settle the matter in mediation.
But the respondent 6 has not paid amount, but you find the execution petition was recorded.
Yes, not?
Page 27, my lord.
Yes, filed execution number 647 of
Respondent number 6. Against the Sanjeeva, petition number 1 and Ravi. He has to pay 23 lakhs.
You have been arraigned as a decree holder, this is judgment debtor.
Yes,
1 and 2. What is the mediation report? Where is that? Where is the mediation report? Mediation report.
Yes.
Yes, madam. Go to page 26.
Yes.
Memorandum of agreement under section 8.
Yes. 27 page.
Yes, sir.
Sanjeeva, amount to be paid. This number 1 is Sanjeeva. Schedule number A, item number 2. The respondent number 6.
So you are entitled for 23 lakhs 34,000.
34,000 to Sanjeeva, number 1.
Who has to pay? Who has to pay?
Respondent number 6, he has filed the execution petition again before.
So respondent number 6 has to pay.
Yes.
Where is that? Where it is stated in the mediation report?
Page number 29.
29. Yes, sir.
Defendant has agreed to pay amount of proceeds.
Defendant has agreed. Just a minute. Who are the defendants?
Defendant number 6, who has filed the
Defendant.
execution was recorded below.
Yes, in case of default in payment, he has agreed to pay the amount 6% interest. Yes, sir.
Before 31st December 2007.
Yes.
Till now he has not paid. And he files the execution petition before below. Again, the petition number 1.
Who files? Yes, sir. The defendant number 7.
Respondent number 6. Yes.
In fact, he has to pay. He has to pay sum of rupees 20 lakhs to you.
There are 2 items. For one item, yes, settled to all. But schedule number A, that is item number 2, he has paid some amount to some people and not paid to this petition 1 and 2. And he files execution petition before the court. And
Told him, under the SCGP accept notice for respond number 1, 2, and 7. Issue emergent notice to respondents. No, that cannot be.
No, otherwise the court will continue.
Nothing will happen. You said, when a counsel appearing for the petition is also permitted to serve copy to the Learner Council representing the parties in execution proceedings. Yes, nothing will happen. Nothing. You challenge one more. Yes, sir. Issue notice. Issue notice.
Appearing for the petitioner.
When a council appearing for the petition is also permitted, sir, copy to the council representative party. Yes. Yes, sir.
May I please?
Yes, sir.
The petitioner had made an application in miscellaneous petition for seeking permission to withdraw his petition and permitted to file a separate petition on the ground that as on the date of entering into compromise, he was a minor, and whatever the grounds are available for the minor was not raised in the miscellaneous petition. Now the trial court proceeded on the assumption that miscellaneous petition itself is not maintained. Therefore, this application is also dismissed. Your lordship may. Your lordship may get.
Take for an example, if former defects which go to the root of the suit, then there is a liberty cannot be given.
No, that is the one. But
that is the law declared by the apex.
That is, your lordship kindly see how the court has proceeded. Para 12, madam.
CPC code. Order 23. Yes. If any formal defects are there,
it is a inherent defect in the petition.
So then the trial court is justified.
It is inherent defect. Therefore, I sought for permission to withdraw the miscellaneous.
That cannot be done. That cannot be done.
No.
Here, the judgment is there on the several judgments on the point. Order 23. Yes, sir.
Before that, I would like to draw your lordship's kind attention to para 12 of the impugned order.
Yes, sir.
The lordship kindly come to para 12.
Just a minute. Go to 23, rule 3.
Rule 3, 1A. Rule 3, lordship kindly see rule 3. Where the court satisfied that is a suit must fall by reason of some formal defect, that there are sufficient grounds to allowing the plaintiff to institute a fresh suit for the subject matter of the suit for part of the claim. It may on such terms, whether this finding is recorded or not. What is the finding recorded by the trial court?
No, order 23.
Rule 3.
Rule 1, subclass 3.
Subclass 3.
Yes. Where the court is satisfied, there are two ingredients. That the suit must fail by reason of some formal defects.
Formal defects.
Or there are sufficient grounds for allowing the institute a fresh suit so it may on such terms as it grant plaintiff permission to withdraw from such suit or such part of the claim with liberty to institute so and so.
Please.
In the case, what has happened? What is the
then your lordship kindly see the regions assigned, whether it is connected to that or not is my question.
Correct.
Your lordship kindly see page 39.
And on what ground you wanted to withdraw?
Well, what has happened? The compromise petition was entered into by mother and my brother. At that time, I was a minor. It was compromised. So then, my lord, what has happened? They filed a miscellaneous petition. So where, my lord, in the formal defect is that the grounds which was available to a minor was not at all taken in their petition. It is a collusion which is affecting the interest of the
issue notice.
Stay of this order.
No, sir. Learner Council is also permitted to serve copy to the Learner Council representative.
One second, my lord.
You serve one.
Serve Martine. One second. Para 12 word bit anantra tavu consider.
I read it. No.
ಅದರಲ್ಲಿ ಏನಾಗಿದೆ ಒಂದೇ
Not a case for, let us will see.
Instituting a fresh.
You sir copy it and immediately.
ಅಲ್ಲ ಅವ್ರು ಏನ್ ಹೇಳ್ತಾರೆ ಮಿಸಿಲಿಯನಸ್ ಮೇಂಟೈನಬಲ್ ಅಲ್ಲ ಅಂತ ಬರೀತಾರೆ ಅದಕ್ಕೆ ಸಿವಿಲ್ ರೂಲ್ಸ್ ಆಫ್ ಪ್ರಾಕ್ಟೀಸ್ ಕೈಂಡ್ಲಿ ಸಿ ಸಿವಿಲ್ ರೂಲ್ಸ್ ಆಫ್ ಪ್ರಾಕ್ಟೀಸ್ kindly see civil rules of practice ತಗೊಂಡು that is my lord court has not taken into law into itself consideration.
Yes.
Kindly see at my lord class 4
if the liberty is reserved for you.
ಅಲ್ಲ ಇಲ್ಲಿ ಹಂಗಲ್ಲ ಇವರು ಏನಾಗಿದೆ miscellaneous your lordship kindly miscellaneous petition ಗೆ justice petition ಹಾಕಿರೋ ತಪ್ಪು ಅಂತ ಹೋಗ್ತಿದ್ದಾರೆ ಅವರು miscellaneous petition
you sir copied it other sir ಬೇಡ
ಈಗ miscellaneous petition dismiss ಮಾಡ್ಬಿಟ್ರಲ್ಲಿ not maintainable ಅಂತ ಇದು ಸರ್ವಿಯರ್
you sir copied immediately.
I will serve it, my lord. There is no problem at all in serving the copy.
Then you serve you serve today.
Problem with the
you serve today.
The problem with the court is that highly misconceived the miscellaneous petition. Miscellaneous, your lordship is aware, whenever an application is made, for the miscellaneous number is to give by the office. Not we are filing. You are filed the application.
You sir copied it.
Original suit itself.
It will be taken up. Next matter. 33.
Your lordship may be finally permitted to serve on the dependent advocate.
Yes.
Advocate
representing the
respondents before the trial
court. Yes.
Please, ma'am.
Yes. Next. Let us give one more opportunity. Finally.
Application came to be allowed in the year 2017. Now not the matters posted for judgment. Again, they come up with the application, and not the same things have been created.
No. Lana counsel appearing for the petitioner seek short accommodation, and same was opposed by the Lana counsel representing the respondent. First, in order to provide an opportunity to the petitioner as a last chance, list this petition next week on date. Nothing will. Monday we have many matters. We have many matters. Nothing will. Otherwise, following week. Then you will have Wednesday. No. Monday, Tuesday. 9th or 10th any day. 10th. Next. Irrigate time waste nobody. Next matter. No. Time is great. It will be
posted
next.
34. I appear for the respondent.
Yes,
your lordship. I filed my statement of objections today. I've served it. It may be taken up next week.
Marking of documents.
Yes.
Section 65.
I can have and there are some judgments point out. Only difficulty is last time they find a memo, either they will not take any discredit. Transport says, lengthy plus given the memo.
Yes.
These do not be posted to not be. So.
Yes, sir. Even the reasons in page 30, the court find that copy of the same has been handed over to the plaintiff, and the plaintiff is not a custodian of the original documents. That's the finding actually recorded by the trial court.
Right.
Yes, sir.
You have filed objection. You will not say that this is not to be marked because near issuance of notice, but please look at it. I can not have a thrown out prepare, as you know. The signature for today, your lordship are aware. I can have inter signature on my letterhead.
Yes.
And what the exact thing is produced, and they issue a notice to me saying that I am ordered to produce this. Is it possible?
Anyway, we will give an opportunity for
no problem. The only thing is not the lordship not be get not the order.
I know.
The lordship may have to give the order of not the trial court.
Yes.
My lord, I have given an undertaking that I will not precipitate the matter before the trial court.
That's my decision.
It's not under 226, sir. 227. 226 undertaking it may be accepted. Not it's because is your challenge order passed by the trial court actually. Yes. Well, stay up further proceedings.
My lord, may I seek a passover, my lord? My apologies, my lord. May I seek a passover?
No, nothing. Stay up further proceedings in OS number 2451 of 2010. till next date of year.
My lord, matter may be taken up next week, my lord. A date may be fixed.
Next week, better. I think maybe or further week. Any day, sir. Not next week, following week. 14th, sir. 14th, it will be taken up. Issue emergent notice.
My lord, I am on record, my lord.
Only one, yes, very good. Interim order 33, no? Interim order granted 33. See, one day nothing will happen. See, next matter, call next matter. For the date, why we have to waste time? Yes, put him.
The respondents, by including my property in the partition suit, the decree was okay. Thereafter,
Which is the impugned order?
Interior matter and seeking stay of my.
No. Which is the interim? Which is the impugned order? Annexure A.
Stay of annexure A.
No. Annexure A. Go to annexure A.
Annexure A.
What is this impleading applicant?
My application.
Who are you?
Application filed by us. They have not filed any objection. Other respondents have not filed any objection. The trial court rejected the same. In paragraph 4, in page 30, all both sides presumed contention made out which is settled principle of that including of additional parties to the decree is permissible only if none of the person already.
Even the RF is also allowed.
Oh, but they have not filed objection.
Yes.
They have not filed objection to that.
You can seek redressal as per law and not under the present proceedings.
The third paragraph, despite granting sufficient opportunity, neither petitioners nor respondents of
correct. In the FDP proceedings, you filed an application for impeding. That came to be rejected, stating that the already the decree passed by in OS has been confirmed in RFA. And then
no, because they would say decree in respect of my property without producing any tax.
Yes. Well, you can challenge. You could have challenged the judgment and decree in OS. You could have challenged the judgment and decree in OS number 2934.
No. In FDP, why was it? Then I came up. See, out of it, I also got converted.
You are a party in OS number 2934.
I am not a party.
Who are you then?
They are family members. They filed suit. Interesting.
Who are you?
I am owner of this particular property. I am not related to them.
Whether that property is a subject matter.
Property is included.
No. Whether this property is a subject matter in OS.
Yes.
Then why you have not been?
No. Only now I came to know that. Immediately I came to know that I filed.
Whether you are party before the party in OS.
I am not a party in the OS.
Go to OS or the judgment and decree.
Lordship may kindly. OS judgment. OS claim at page 61 it starts. OS claim.
Page starters?
61 is page 61. Sushilamma, Droba, Manjula, Soma, Surnamma, Shardama.
1 minute. 61. This is a suit for partition. So, what is your grievance?
In page 68, item number 6.
60?
That is my property.
68.
Any documents.
Which is the item?
Survey number 78/2.
You are not a party in OS.
Yes, I am not a party.
You are a owner of the property?
Survey number 78/2. In fact, that measures 3 acres 17. They have mentioned it was in the 2 acres 15. I have produced all the documents to show that we are the one who are in possession of the property. Till then. In 1953,
anyway, this order has been confirmed in RFA.
That is filed by them. That is between them. I am not a party at all. In fact, our High Court.
What you have produced? What is the material that you have produced before the trial court to establish your right over the property?
Up to date RTC, Conversion order was obtained by the 2012.
RTCs are the present.
Conversion order, 2002, and I have produced a decree.
Conversion is only pursuant to the RTC. Anything to produce your right over
Yes, in 1953, there was a suit for partition in the state suit itself between my family members.
Yes,
I
Annex
produced
D.
that also.
Annex D.
It is that exhibit that
Annex D.
Annex D. That's between my family members. Property is my grandfather.
Where is the property number so and so is stated in your
schedule? It is there in the schedule. Mutation was affected.
No, where is the schedule?
But there is a reference.
No. Where is the schedule? To show something that survey number 78/2 is belong to.
Yes. Regarding that.
No, that is only in the suit, in the said suit.
Regarding that, you lordship may kindly see in page 47, mutation was affected in 19.
Not mutation. Mutation RTC you leave.
Based on that only.
No. Based on decree. Where is in the decree? Where is in the decree it is stated that? Where is the schedule to the decree?
Schedule to the decree is not furnished.
Then?
But however,
however, it has to be produced. No, however, it has to be produced. Yes. See, normally decree contains the schedule. Decree contains the schedule.
That is the copy furnished to me by the court.
No.
In 1953 suit.
No, not furnished. It is your suit. You must have.
1953.
You must have. How survey number 78?
78/2.
Yes. Where is it is treated in the said OS number so and so. Annex D.
Tomorrow I will produce decree.
Then a council applying for the petition seeks short accommodation. This next week.
Seventh case is there.
Nothing will.
Decree produce. To show that in 1953 it was there.
Just tomorrow.
Even otherwise.
No, tomorrow. Once it's stated tomorrow, that's yes.
As directed by thoughts on 28.
Yes, sir.
This is a case law where this petitioner.
Yes.
Under Annexure B, which is at page 24.
Yes, sir.
What was has been granted a lease.
Yes. By the government. Yes.
By the government. Probably it is also there.
Yes.
But what happens is by Annexure C, this is a document of 1984.
Yes.
Mahadevamma, she had was granted 1 acre of land.
Yes, sir.
Date of the order grant or certificate is 24/10/1984.
Yes, sir.
But after this grant, she had filed a suit, Annexure D, page 56. Saying that she is in fact in possession of 1 acre in survey number 46.
Yes, sir.
And not survey number 181.
Yes, sir.
That suit came to be dismissed.
Yes, sir.
But after this, she gives a representation to the government saying that consider my case.
Yes.
That I am in 181. She files a writ petition, page 65. Annexure E is the writ petition where this honorable court directs that her representation should be considered.
Correct.
Operative portion is at page 71. Paragraph 10.
Yes, sir.
Pursuant to this, the Special Deputy Commissioner passes an order in 2001, on 11th of April 2001, Annexure F, page 72, and rejects her claim by saying that
there is already a suit
Yes.
that was filed. In the meanwhile,
Yes.
she transfers the land by Annexure G by way of a sale deed on 19/7/2002 in favor of a person by name Krishna.
Yes.
Now, but after this, there is one more order, Lord.
Conversion.
The
Deputy Commissioner. Yes.
Annexure J, page 99, wherein, Lord, this her case was considered, and the operative portion, of the order, noting the fact that 110, page 110,
Yes.
refers to the fact that the suit was dismissed, and then, Lord, her request is not considered. However, a survey is ordered.
Yes. The land may be surveyed and measured according to their respective actual position.
Yes.
And then so on. So.
Lord, there was already a suit where there is a declaration that she is not in possession.
Yes.
However,
Revenue authorities cannot enter.
That is what is recorded, but still there is a survey order.
Yes.
Now, Lord, there is a suit that is filed by this transferee, Krishnappa, in a
Yes.
suit.
From the
710/2009.
Yes, sir.
That is Annexure K.
Yes.
Is a claim asking for injunction.
Okay.
The suit for injunction.
Yes.
But what happens in the meanwhile is
Claiming that the scheduled land has been granted to the
yes, granted based on-
to his vendor.
yes.
Yes.
Now, Lord, there is one more order that was passed.
What happened in OS?
OS, Lord,
710 of 2009.
Lord, in the meanwhile, Annexure N had been passed, which is at page 233. One more order by virtue of which 233.
233. Yes.
One more order has been passed,
Yes.
stating that correction should be done. Now only survey number is corrected. 240 is the operative portion.
240. Yes.
240. Last line, Lord. ನೀಡಿರುವ ಸಾರ್ವಜನಿಕ ಚೀಟಿಯಲ್ಲಿ ನಮೂದಿಸಿರುವ ಸರ್ವೆ ನಂಬರ್ 181 ರದ್ದುಪಡಿಸಿ ಸರ್ವೆ ನಂಬರ್ 46 ತಿದ್ದುಪಡಿ ಮಾಡಿ ಆದೇಶಿಸಿದೆ.
Whether this order under 49 has reached finality was not challenged.
Lord, this is challenged in the present representation. And Lord, also I have given a representation.
In the present representation.
In the suit was referred to Lok Adalat.
It is a challenge whether the order passed in under section 49.
Yes.
49. Whether it is challenged, 233.
233 page, Lord. That is challenged in the present proceedings, Lord.
Not in. This is GMCPC course, not GMKLR. That was with GMKLR.
Yes.
Sorry, it has to go WPKLR.
Pursuant to this order, Lord, the suit was referred to Lok Adalat. Before the Lok Adalat, Lord, parties filed a joint memo of compromise. Under that compromise, Lord, for this 1 acre of land, 3 crores is Lord paid at page 145.
145.
There was also, Lord.
This is 2009.
Yes. 2018.
M alla?
Annexure L, page 145.
145. 710 of 2009.
Yes, ma'am.
Yes, sir.
Two came to be compromised before Lok Adalat. That is the order sheet. And 3 crores was paid. And the defendant, the plaintiff, was supposed to execute documents.
So petition is not is also a party actually.
He was a part. He was the defendant in the.
Correct.
Now, Lord, he was supposed to execute a document of confirmation of title in my favor. When that issue came, Lord, it is realized that the whole thing is fraudulent because only 7 number is changed. The boundaries do not match.
Extent of land.
And now, Lord, what has happened is,
Yes.
because the value of 7 number 46 has gone up,
Yes.
because of this institution coming up there,
Yes.
there are n number of applications now asking to shift their
Yes.
land from 181 to 46.
Yes.
Therefore, Lord, I have challenged, Lord, the compromise decree, Lord, because it was in Lok Adalat. There
Yes.
are judgments which say, Lord, it could only be challenged by
Repetition.
That is the background in which, Lord, I am before my lords.
My only interim prayer that I am seeking, not in the.
Not to change the entries.
Not to change the entries pursuant to Annexure N.
Yes.
That is the representation that I had given, which has not got elicited any response as on today. I
Yes.
shall repeat my representation.
Yes, sir. So, when I receive GP accept notice for R1 and R2, issue emergent notice to 3 and 4. And respond number 2 is who is a deputy commissioner. He is restrained from making any change in survey number, making any change in the mutation entries. It is sufficient.
Or grant order.
Mutation entries.
Directions are being issued to change the survey number in the grant certificate.
Or else Annexure N.
Annexure N is the order by which.
So all do one thing. All further proceedings in pursuant to the Annexure N is stayed.
Based on this, they should not change because there are other claimants.
Other claimants.
Yes.
So restrain the second respondent from change of survey number as 46 in place of other survey numbers of Galipura village, Bangalore South Taluk, Bangalore South Taluk, Bangalore, and the stay of the operation of the order dated 6/4/2017 by the 6/4/17 by
special deputy commissioner.
that is Annexure N. That is Annexure N. Annexure N. Yes. Till next date of N. Yes.
Number 37. Vijay Kumar. Serial number 37.
Yes. Order 6/17. Yes, correct.
Only on the ground that I have not created this position.
At what stage it was filed? At what stage this say the application was filed?
After the filing of the return statement, now the issues have been framed.
Yeah, yes.
The evidence is yet to become.
Yes.
So I filed an application. The temporary injunction is also granted in my favor. The suit is for mandatory. I want to convert this into a declaration and for mandatory.
Issue emergent notice. No. That cannot. Nothing it is in the.
My submission is.
Let us wait. Lana council appearing for the petition is also permitted to serve copy to.
Submission is totally 5 suits are there.
I know. Let us we will see.
Filed in the 3 petition interim order was passed.
Where is
this is ಇದರ ಕೊಡಿನದ ಮತ್ತು ಅವರ ಈ ಸೂಟಲ್ಲಿ ಆಫೀಸ್ ಅಪ್ಡೇಷನ್ ಕಂಪ್ಲೈಂಟ್ ಇದೆ.
There shall be further proceedings. They submitted that in the identical suit in which the petitioners filed an application under Order 6/17, which came to be dismissed, and this court has granted interim order. So accordingly, the interim order has prayed for. Yes. 38 also same. 38 also same. Yes, sir.
Number 39.
I beg to appear for the petitioner in this case, my lord.
Issue notice. Issue emergent notice. Yes.
The matter is posted for arguments. May I request for stay?
Let us. You may serve a copy. So order 18 rule 7 application. Let us release.
My lords, on the very next date, my lords, after the
yes, let us issue emergent notice.
My lords, I may be permitted to take out.
Council for yes, sir. Permitted to take out notice on the Lana council representing the parties. Immediately can move it.
Please, great.
Yes.
I appear for the petition, my lord.
Yes, sir.
This matter, my lord, this suit, there were 2 suits. One suit filed by them was dismissed and it came to an end. For injunction has been granted in respect of that land, that disputed land. Now, after the decree for injunction, they attempted to enter upon this portion and put up a structure. Then I filed an execution saying that it's a violation of the injunction order, arrest him and keep in civil prison. Then he said that I have not violated. Evidence was. I filed an application to appoint a commissioner to measure the area as whether there is an encroachment or not. That measurement done only by physically somebody going there and doing that decision is rejected. So physical measurement on the spot is required to find because we are adjoining owners. There is no dispute. So what is the area I am having? What is the area he has occupied? If he has occupied, he is liable to be arrested. If he has not occupied, he is not liable to be arrested. That has to be done by physically measuring.
What is there in the judgment and decree?
I am not challenging the judgment and decree. It is not in a dispute. And as per the decree, whether they have occupied or encroached or not has to be found out by physically measuring. And there is no dispute between the parties regarding the measurement.
Issue emergent notice.
Also ask for stay.
No, sir. No, sir. No. Order 26.
Then I may permitted to serve on them.
Yes, sir.
On the
Permitted to
advocate.
serve copy to the land council representing before the execution proceedings. Yes, sir.
The appeal is now for hearing he has filed objections. So district court is refused to give stay, my lord, and the execution petition is pending. So my appeal will become infructuous if the execution is allowed. So appeal may be directed to be disposed of in 1 month or stay may be granted.
Yes, yes. Appeal is of the year 2020.
2020.
Now is serial number 41, na?
41. 41. See, dismissed the IA, seeking stay.
There are no grounds for stay.
I know. Except setting the pressure price the only property for a livelihood.
But my appeal has so many grounds.
Of course, he has already suffered an order by the trial court. Otherwise, granting of stay under 41 Rule 5 is a discretion that cannot be interfered. Only thing is, I can direct the first appellate court to dispose at the earliest. No. Nothing. The finding recorded by the first appellate court at para 8 is just and proper.
It is not my property at all. In my appeal memorandum, I have listed so many grounds, but in the stay application, only one ground is given.
Yes. Yes, sir. I think not a case for interference actually.
Then time may be fixed, I will argue.
After so that it may be disposed of with directly first appellate court to dispose of this. That may be dispose of the appeal. Or the Land Council appeal for the petitioner. After arguing for some time, Land Council appealing for the petitioner submitted that the first appellate court be directed to dispose of the petition at the earliest in RA number 6 of 2020 on the file of the third additional district and session judge at Chikkaballapura. Perusal of the writ petition would indicate that you are the defendant before the trial court. Defendant as preferred. RA number 6 of 2020 on the file of the first appellate court, challenging the judgment and decree dated 6/10/2018 in OS number 10 of 2018 on the file of the senior civil judge JMFC Gauri Bitto. Full stop. Having taken note of the grounds urged in the memorandum of writ petition and the finding recorded by the first appellate court on the application filed by on IA number 2, I'm of the view that I do not find any error any infirmity in the order passed by the first appellate court. Declined to stay the judgment and decree in OS number 10 of 2018. However, taken into consideration the arguments advanced by the learned counsel appearing for the petitioner with regard to the apprehension expressed by him insofar as the property, insofar as the subject matter, insofar as the property in question. I'm of the view that the first appeal could be directed to dispose of the appeal within 6 months from the receipt of this order.
6 months.
No, let us will see. I do not the board in first appeal. I don't know how many RS are there. That there will be. Yes. From the receipt of the order. Next matter. Notice. Emergent notice, not a case for emergent notice. I know.
As if it is permitted the defendant to serve construction, subject to executing the bond of duty on that.
Yes.
I should have been asked to execute.
No. Learned counsel appearing for the petitioner is also permitted to serve copy to the learned counsel representing the counsel before the trial court. Yes, sir. Order 6, Rule 17.
Rule 17. Lost my case is plain. Though it is a simple suit for amendment of the application, plainly see the plain.
It came to be allowed.
Plainly see the schedule. Page 14.
Page
14. Permanent injunction character. Schedule property survey number 17/1. Measuring 23 gunta. So on out of it, an extent of 15 feet into 33 feet.
Anyway, the suit will be conclusively it will be decided.
Declaration claim absolutely have objection. Plainly see the application file.
Application
file for amendment. Able copy annexation page 33.
Page 33.
And page
Yes.
35.
Proposed amendment sought for.
Page 35. Reschedule paragraph number 3.
Yes, sir.
To delete the schedule, purti adana.
That cannot be.
And added so on. So.
Yes.
That cannot be done. Iಷ್ಟಕ್ಕೆ declaration ಕೇಳಿ possession ಕೇಳಿ absolutely have objection.
Yes.
ಅವರು ಪೂರ್ತಿ ಇದನ್ನು delete ಮಾಡಬೇಕು. Substituting the schedule. Schedule A and schedule B. That is not permissible.
Yes. Step further proceedings in OS number 231 of 2015 on the file of the civil judge and JMFC Bagepalli. Within bracket annexure F. Yes. Issue emergent notice.
Number 44.
Yes, ma'am.
Increasing application filed by the petitioner of High Court has rejected the increasing application filed by the petitioner. So what is happening was petitioner hearing members
On what ground it was?
Filed a suit for declaration matters.
Correct.
Declaration of easement and right matters.
Yes.
And permanent injunction.
What is your interest actually?
Actually.
What's the interest of the impleading applicant?
Please, my lord, respondent number 1, my lord, has sold the suit schedule property to the, that is part of my property, my lord.
Yes.
That is suit schedule A property has sold part of the suit schedule A.
Yes.
As well as suit schedule
Issue
B
emergent
property.
notice. Let us will see.
My lord has sought for stage.
No. What is the stage in this?
Stage, my lord,
It is only 2018. Let us will see. Learned counsel appeal for the petition is also permitted to serve copy to the learned counsel representing the party. It's only order 1 rule 10. Let us will see. You serve it and move it. You serve it and move it. Let us will see.
actually, trial court has allowed the similar applications. My lord.
Yes. Let us serve it and let us. You serve it and move it. Let us hear the other side. It may be taken up for final disposal. Yes.
Paper the petition.
Yes, sir.
I'm a dependent in the suit, my lord.
Dependent. Yes.
Yes, my filed an application to file for records from PDA. The case is that, my lords, my father was the owner of the site.
Your father is the owner of the site.
Yes, my lords. Now, the second plaintiff in the case has impersonated my father and included him as the first plaintiff. And in spite of an order by the court to keep the first plaintiff present, that was not complied. My case before the honorable trial court is this is the modus operandi of the second plaintiff to create documents and take documents from BDA.
Yes.
So my site is site number 3. There's another site number 72.
72.
72. So in the cross examination, I asked him a question. Similar modus operandi operated.
See, this is your signature, this is your handwriting. He denies that.
Yes.
No, my lords, then immediately in March, I filed the application.
Issue emergent notice. Stay of all further proceedings in OS number so and so, page 69. Till next date of hearing.
Yes.
Okay. Yes. B group. No. In only in 10th. The number of memos are.
ಹೌದಾ ಅದೇ ಬಿಟ್ಟು ಬಂದಿದ್ದೀರಲ್ವಾ ಇಲ್ಲ ಬಂದಿಲ್ಲ ಎಲ್ಲ ಮಾಡೋದಿಟ್ಕೊಂಡು ಒಂದು ಇಸ್ಕೊಂಡೋಗ್ಲ ಬೇಡ ನಾನು ಇವ್ರ ಹತ್ರ ಕಳಿಸ್ತೀನಿ ಅಂತೆ ನೀವು ಇಟ್ಕೊಂಡು ಬೇಕಾದ್ರೆ ಯಾರಾದ್ರೂ ಪ್ರೆಸರ್ ಅಂತ ಕಳಿಸ್ತೀನಿ ಕಾಲ್ ಮಾಡೋಕೆ ಅಲ್ಲ ಅಲ್ಲಿ ಆಗ ಇವತ್ತು ತಂಗಿ ಬಂದಿದ್ದಾರೆ ನಾನು ಪೆಂಡಿಂಗ್ ಅಂತ ಅದಕ್ಕೆ ನಾನು ಸಬ್ಮಿಟ್ ಆಗಿತ್ತು ಡೇಟ್ ಇನ್ನೂ ಗೊತ್ತಿಲ್ಲ ನೀವು ಸ್ವಲ್ಪ ಆದ್ಮೇಲೆ ಬನ್ನಿ ನಾವು ನಿಮ್ಗೆ ಯಾವ್ದು ಬಟ್ ನಾನು ಇನ್ನೂ ರಿಜಿಸ್ಟರ್ ಬರ್ತಿರೋದ್ರೆ ಈಗ ನಿನ್ನೆ ಮತ್ತೆ ಟ್ವೆಂಟಿ ಎರಡು ಮಾಡಿದ್ವಿ ನಿನ್ನೆ 4 ರೀಚ್ ಆಗಲ್ಲ ಕೇಳಿಸೋದೇ ಇಲ್ಲ ನಾನು ಆಮೇಲೆ ಈಚೆ ಬಂದು ಮಾಡ್ತೀನಿ ಈಚೆ ಬಂದು ಮಾಡ್ತೀನಿ ಹೇಳಿ ಯಾರು ಬಂದಿದ್ದಂತ ಹೌದಾ ಏನ್ ಮಾಡೋದಿಲ್ಲ ಕಳಿಸ್ತೀನಿ ಬರ್ತಾರೆ ಅಡ್ವೊಕೇಟ್ ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಕಳಿಸ್ಲಾ
ಅವ್ರಿಗೆ ಹೇಳಿದ್ದೀನಿ ಬಂದ್ರೆ ತಿರ್ಗಿ ಅಲ್ಲೇ ಕಳ್ಸಿ
ಫೋನ್ ನಂಬರ್ ಇದೆ.
ಸರಿ. ಅದು NMS ಗೆ ಉಟ್ಕೊಂಡು ಹೋಗಿ ಅಂತ ಹೇಳದಾ?
ಅದೇ ಹೋಗೋಣ.
ಏನು ತಲೆನೋವು ಇವೆಲ್ಲ ಅಮೆಂಡ್ ಮಾಡಿಲ್ಲ ಅಲ್ವಾ?
ಮಧ್ಯಾಹ್ನ 20 ಮಂಡಲ್ ಮಾಡಿದೆ.
ನಾನು ಕಳಿಸ್ತೀನಿ NMS ಹತ್ರನೇ ಅದೇ ಅವ್ರಿಗೆ ಹೇಳ್ತೀನಿ ಅಡ್ವೊಕೇಟ್ ಬರ್ತಾರಂತೆ ನಿಮ್ಮ ಹತ್ರನೇ ಇಟ್ಕೊಬೇಕು ಅಂತ. ಅಂತೂ ಅವ್ರಿಗೆ ನನ್ನ ಅನುಕೂಲ ಎರಡೇ ದಿನ ಕಾಲು ನಮ್ಮ ಸಾಹೇಬ್ರೆ ಕಳಿಸಿ ಮೇಡಮ್ ನನಗೆ ಕೂಡಕ್ಕೆ ಬಿಡಲ್ಲ. ಅದಕ್ಕೆ ಫಸ್ಟ್ ಕೇಳಿದೆ ನಮ್ಮ ಸಂತೋಷ ತಿಂತಾರ US ಹೋದಾಗಿಂದ ಇವತ್ತು ಸುಮ್ಮನೆ ನನಗೆ ಆಗೋದು ಅವ್ರು ತಿಂತಾರೆ ಅಷ್ಟೇ ಮಂಚೂರಿ ನನಗೆ ಅದು ಇದ್ದಿಲ್ಲ ಅದೇ ತಿನ್ಬೇಕು ಅಂತ ಒಂದು ಪುಸ್ತಕ ತಿನ್ಬೇಕಂತ ಆಮೇಲೆ ಬರ್ತೀನಿ ಅಂತ ನನ್ಗೇನು ಬೇಡ ಇದೇ ಜಾಸ್ತಿ ಆಗ್ತದೆ ಒಂಚೂರು ಕಮ್ಮಿ ಆಗುತ್ತೆ ಇದು ತಿನ್ನೋಷ್ಟು ಖುಷಿ ಇಲ್ಲ ಆಗಷ್ಟೇ ತಗೊಳ್ಳಿಲ್ವಾ ನೀವು ತಗೊಳ್ಳಿದ್ರು ಏನು ತಗೊಂಡಿಲ್ಲ ಯಾಕೆ ಕೊಟ್ಟರು ಅಂತ ನಮಸ್ಕಾರ ಎಷ್ಟು ನಮಸ್ಕಾರ ಬಂದೋದೆ ಎಷ್ಟು ಅವರು ಆಲಸ್ಯದು ಒಂದು ಕೊಟ್ಟಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಬಂದ್ ಮಾಡೇ ಇಲ್ಲ ಅವ್ರಿಗೆ ಪೆಟ್ರೋಲ್ ಸಿಕ್ಬಿಟ್ಟು ಕಮ್ಮಿ ಏನಾದ್ರು ರೈಸ್ ತಂದಿದ್ದೀನಿ ಮಾಡಿ ಆಮೇಲೆ ಆಗ್ಬಿಟ್ಟು ಅನ್ನ ಮುಂದೆ ಅದಕ್ಕೆ ಅದಕ್ಕೆ ಬ್ರಾಕೆಟ್ ಅನ್ನ ಹಾಕೊಂಡೆ ಬಿಟ್ಟಿದೆ ನಾವು ಏನು ತೆಂಗಿನಕಾಯಿದಾಗ ಮೂವ್ ಆಗುತ್ತೆ ಈ ಟೈಮ್ ನನ್ನ ಮಗಳ ಉದ್ಯೋಗ ಮಾಡಕ್ಕೆ ಕೈ ಮಾಡ್ತಿದ್ದಾರೆ ಇಲ್ಲ ಏನಾಗ್ತಾ ಇದ್ದೀರಾ ಸೆಕೆಂಡ್ ಮಾರ್ಚ್ ಸೆಕೆಂಡ್ ಹಂಗೂ ಒಂದು ಆಪ್ಷನ್ ಏನ್ ಗೊತ್ತಾ ಮನೆಗೆ ಹೋಗಿ ಮನೆಯವ್ರ ಹತ್ರ ಮಾತಾಡ್ತೀನಿ ನಮ್ಗೆ ಅಲ್ಲಿಂದ ನೆಕ್ಸ್ಟ್ ರೋಡಿಗೆ ಕಾರಲ್ಲಿ ಹೋಗ್ಬರೋಣ ಮಾತಾಡ್ತೀರಾ ಅಂತ ಕೇಳ್ತೀನಿ ಮನೆಯವ್ರ ಎಸ್ ಅಂದ್ರೆ ಅಟೆಂಡ್ ಮಾಡಿ ಮನೆಯವ್ರು ಹೋಗ್ಬೇಕು ಕರ್ಕೊಂಡು ಬರ್ತೀರಾ ಕಾರಲ್ಲಿ ಹೋದ್ರೆ ಮಾಡಿ ಬೆಳಗಾವಿ ಮತ್ತೆ ಬೆಳಗ್ಗೆನೆ ಎದ್ದು ಬರ್ಬೇಕು ಅಲ್ಲ ಇವಾಗ ಹೋದ್ರು ಬರೋದು ಲೇಟ್ ಆಗ್ಬಿಟ್ರೆ ಮತ್ತೆ ಬೆಳಗ್ಗೆನೆ ಎದ್ದು ಬರ್ಬೇಕು ಇವತ್ತೇನು ನೀನಿಲ್ಲ ಮನೆಯಲ್ಲಿ ಅಂತ ಮುಂದೆ ಇವತ್ತು ಬೇರೆನೂ ಬಿಟ್ಕೊಡ್ತೀನಿ ಏನು ಎಲ್ಲ ಮುಗಿಸೋದು ಕ್ಲೀನ್ ಮಾಡ್ಕೊಳ್ಳೋದು ತಿನ್ನೋದು ಹಬ್ಬ ಕುತ್ಕೊಳ್ಳೋದು 3 ಜನ ಮಾತಾಡೋದು ನಾನು ಅದಷ್ಟು 3 ವರ್ಷ ಆಯ್ತಲ್ಲ ಸರಿ ಹೋಗಿಲ್ಲ ಅಂದ್ರೆ ತಂಗಿ ನೆಕ್ಸ್ಟ್ ಇಯರ್ಗೆ ಅದಕ್ಕೆ ಶಿಫ್ಟ್ ಆಗ್ತಾರೆ ಇಲ್ಲ ಅವ್ರನ್ನೇ ಅಪ್ಪ ಅಮ್ಮ ಇದ್ದಾರಲ್ಲ ಸ್ಕೂಲಲ್ಲಿ ಅವರೆಲ್ಲ ತಂಗಿ ಕೆಲಸ administration university business ಯಾವ ಕೊಟ್ಟ ಅಂತಾನೆ ಗೊತ್ತಿಲ್ಲ ಎಲ್ಲ ಕೊಟ್ಟು ಫಸ್ಟ್ ಯಾವುದು ಅದ್ಯಾವುದು ಇಲ್ಲಿವರೆಗೂ ಡೆಟೇಲ್ಸ್ ವರೆಗೂ ಹೋದ್ರು ನಮಗೆ ಮತ್ತೆ ಏನು ಸಜೆಷನ್ಸ್ ಏನೇನು ಇನ್ಫಾರ್ಮೇಶನ್ ಸೊ WPP ಕೋರ್ಟ್ ಎಲ್ಲ ಹೋಗಿ ಇನ್ಫಾರ್ಮೇಶನ್ ಕಲೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ ಅಲ್ಲಿ ಮೊನ್ನೆ ಹಂಗಿಲ್ಲ ನಾಳೆ ನನಗೆ ಬೇಕಷ್ಟೇ ಅಯ್ಯೋ GM ಅಂದ್ರೆ ರಿಲೀಸರ್ ಅಂತ ಅದಕ್ಕೆ ಈಗ GM ಬೆಳಗ್ಗೆ ಇಲ್ಲ ಮಧ್ಯಾಹ್ನ ಎಲ್ಲ ಪುಡಿ ಮಾಡ್ತಾರೆ ಪುಡಿ ಮಾಡಿದಾಗ ಎಷ್ಟು ಹೌದಾ ಸರ್ ಆಮೇಲೆ ಇವರು ಬರ್ತಾರಲ್ಲ ಸರ್ ಪದ್ಮ ನಾನು ಮನೆಗೆ ಜಾಸ್ತಿ ಹಾಕೊಂಡಿದ್ದೇ ಇಲ್ಲ ಈ ಸೈಡಿಂದ ತೆಗಿತಾರೆ ದೂರದಿಂದ ಏನ್ ಮಾಡಿದ್ದಾರೆ ಕರ್ಕೊಂಡು ಮಾಡಿ ಹೇಳಿದ್ದಾರೆ ಯಾರೇ ಬರ್ತಾ ಇದ್ದಾರೆ ನೋಡಿಲ್ಲ ಕ್ಲೀನಾಗಿ ಖರ್ಚು ಗೊತ್ತಿಲ್ಲ ಇದು ನಾನು ಪದ್ಮ ಮನೆಗೆ ಜಾಸ್ತಿ ಹಾಕೊಂಡಿದ್ರು ಆಮೇಲೆ ಪದ್ಮಗೆ ಯಾರೇ ಬರ್ತಾ ಇದ್ದಾರೆ ಅದೇ ಭಯನ ಸಂಕಟ ಬಂದಿರೋದು ಅದೇ ಇದೆ ನಾವು ಹಿಂಗೆ ಕೆಜಿ ಓಡೋದಿದೆ ಆಮೇಲೆ ಅನ್ಬೋದಾಗಿಲ್ಲ ಆಮೇಲೆ ಅದೇನಿಲ್ಲ ತಲೆ ಮಾಡಿ ಅವರೇ ಕಷ್ಟ ಕಟ್ಕೊಂಡು ಹೋಗಿದ್ದು ಅವರೇ ಸ್ವಲ್ಪ ಅದಕ್ಕೆ ನೀವೇನ್ ಖರ್ಚು ಹೇಳ್ತಮ್ಮ ಹಲೋ ಮಾಡ್ತಾ ಇದ್ದಾರೆ ಹಲೋ ಶೀಟ್ ಪೇಪರ್ ಕೊಡ್ಬೋದು. ಅದು ಸಖತ್ ಡೇಂಜರ್. ಆ ಡಬ್ಬಿನ ಅಲ್ಲೇ ಅಲ್ಲಿ ಬಿಟ್ಬಿಡಿ. ನಮ್ಮಲ್ಲಿ ವಾರ ಎಲ್ಲ ಮುದ್ದೆ ಮಾಡ್ಕೊಂಡು ಇದು ಈಗ ಸದ್ಯ
Court office.
Live stream.
Ask for even. Ask for
matter. Serial number 51. The series under picture.
Yes.
Appeal for the respondent bank, my lord.
Yes, sir. Yes.
My lord, last time your lordships heard me, my lords, and your lordships were kind enough to permit me to file the account statement.
Yes.
My colleague is before your lords, my lord. We are
yes,
furnishing the account statement.
Very
the total outstanding amount is 17,63,000, my lord, as on date. I produced all the account statements.
Yes, sir, copy to him. Sir, copy to him. Sir, you verify it. So that I will look into it then. I think anyway I have heard you, both of you.
My lord, I'm also placing some judgments on record, my lord.
Yep, furnish. Yes, sir.
My lords, the last judgment I'll take first, my lord. May I draw your attention to page number 30, my lord?
There's a recent judgment on OTS by Supreme Court.
That also I have produced, but this is Karnataka High Court judgment, my lord. Page number 30.
30.
30, my lord. It starts at 29. The relevant portion is at page number 30, my lord. Paragraph B, if I may read, my lord.
Paragraph?
Paragraph B, my lord, on page number 30.
The argument that.
The argument that the bank being an instrumentality of state.
Yes, sir.
The bank being an instrumentality of the state under section 12 of the Constitution of India ought to have given reasons in the impugned communication itself for rejecting petitioner's request for financial assistance under the credit guarantee scheme cannot be countenanced. The respondent bank is not a statutory authority in the sense the Election Commission of India was treated in Manohar Singh Gill. The response of a bank to the requirement of its borrowers made in the course of its commercial dealings cannot be approximated to an order of a statutory authority. The principles on which a bank's response to its customers have to be examined in a judicial review are much different from the ones that ordinarily apply to the review of administrative actions of these statutory functionaries. A decision is an authority for the proposition that that is actually laid down in a given fact matrix and not for all that which logically flows from what has been so laid down. Then next paragraph, my lord. The respondent bank, ideally speaking, could have given the gist of its contentions as taken up in the statement of objections in these proceedings, in the very impugned communication itself. Had it been done, there would have been no scope for the argument that the impugned order is not a speaking order and therefore it should be voided. This super adding of reasons to affidavit or counter not being permissible, as already mentioned above, a response of a commercial bank cannot be equated to an order of a statutory authority. Added to this, it was open to the petitioners to solicit a detailed reply from the bank as to why it was not given.
Ultimately, the writ petition came to be dismissed.
My lord?
Ultimately, the writ petition came to be dismissed.
It was filed by the borrower and the writ petition was dismissed.
I shall consider.
Yes, my lord. One more decision also I am relying on, my lord, again of Karnataka High Court, at page number 23, my lord.
That's everything.
Page number 23, my lord.
That's a division bench judgment.
Indeed, my lord.
Dharwad.
Correct. Kalburgi High Court. I mean, bench Kalburgi bench. Dharwad bench. Sorry. Dharwad bench, my lord. At para 3, my lord.
That was under Surface Act.
My lord. Yes, my lord.
SPC
SPC Act and OTS, my lord. Specific issue was OTS. It same to the incident case, page number 22,
Yes.
my lord, for a moment.
Yes.
Page number 22. In the last paragraph from below, my lord, foundational facts emerging from record.
Yes, sir.
The respondent Canara Bank is the lender. Writ
I
petition
shall
who
repeat it. I shall repeat. Yes. Sorry. Heard and reserved.
Much obliged.
Yes. Ready? Copy. Yes. Yes. Sir. Please, sir. Copy. Correct. But to hold in the proceedings. Yes. Only it is if it is relevant, better. Because unnecessarily we don't have to waste time. Yes, sir. Yes, sir. Yes, sir. Yes, sir.
So, no, the rectification is executed by Shri Krishna Kumar.
Yes.
Page number 56, the rectification
Yes, yes, yes.
executed by Shri Krishna Kumar based on GPA executed by Shesha Sai Venkatraman.
Yes.
Page number 56.
Yes, sir.
In favor of the petitioner is.
Yes, sir.
So, if you don't know, first of all, Shesha Sai Venkatraman obtained this rating from Monshi Bhatti Manju.
You go to that, what is the impugned order? That's not. Yes.
This rectification deed out Marco. He has to establish that.
Yes.
Anyway,
the title.
Because we have no title. We have no title to execute a rectification deed.
But this argument in OS. This argument in OS. Yes.
In that particular city, there is no serial number. Even when there is no serial number in the 1995-1993.
So according to your identification of the property itself, that can be looked into in the.
Let them construct an objection. But if there is any create third party intersection,
yes. So based on this, just I prepared a small judgment is ready. I had to be because I don't want to waste time. Just I will read the parent time. So, automatic writ petitions allowed. Undisputed, the appeal is pending consideration before this court, and rights of the parties is said to be crystallized in the said appeal. However, taking into consideration the finding recorded by the trial court on IA1, which ultimately reached a finality in WP number so and so, and taking into consideration the arguments advanced by the learned counsel appearing for the petitioner, I am of the view that the writ petition deserves to be disposed of by setting aside the orders passed by the courts below on IA2 by putting the defendant number 1 on terms. In that way to matter, this court directed the petitioner hearing to file an undertaking by way of affidavit that any construction that may be made on the scheduled property, the same is scheduled property. The same is subject to the result of the judgment and decree that may be passed by the trial court in OS 26 of 21. It's also made clear that the petitioner defendant number 1 cannot claim equity in the matter, and in the event of suffering decree in the suit, the defendant number 1 has to demolish the construction so put up on the scheduled property as stated. Yes, sir?
Dispose of the suit. So there is not to create a third party decision. In case
bargain the title. You can't. No. See, even if any intending purchaser, you cannot take chance. Of this affidavit. No. That's it. No, nothing. The third, they won't do that. This pendency is there, nothing to do with it. Nothing, big group point. Here nothing will happen. Nothing else. Yes, 1 minute. What is implement, sir?
Implement is on my application under order 21 rule 32 sub rule 5.
21 rule 32.
Seeking restitution of the property in question.
Yes, sir. That's annexure?
Annexure A. I filed an application.
Dated, which is that date? That is 16/3/2020. 1 minute. You are the decree holder.
I am the decree holder.
Counsel for decree holder represent files application 20 daily newspapers. 16/3/19 for production of paper publication. Social properties bearing social property number claimed is in. Read, please. Just read. Which is that order that you challenge?
This is you will find the operative question of the order at page 38. It is the
1 minute. 38.
Handwritten matter.
That's right.
The title copy is at page 38.
Okay.
I am permitted to read.
Please.
DHR Council filed IA under order 21 rule 32 sub rule 5 of CPC, seeking to restore the vacant possession of the decretal property. Admittedly, DHR obtained a decree for permanent injunction, has come up with this execution petition alleging disobedience of said decree for permanent injunction. This application filed by DHR under order 21 rule 32 5 of CPC and annexed affidavit probabilizes altered circumstances as a result of the alleged act of DDR by way of this application. DHR is seeking to restore possession, which is neither the scope of decree nor the provision under order 21 rule 32 rule 5 of CPC. This application filed by DHR makes the matter complicated and not being within the purview of decree. This executive court cannot entertain such applications, and it is for the DHR to file a fresh suit in this regard. Accordingly, application filed by DHR under order 1 or 21 rule 32 5 of CPC is rejected as not maintainable.
Yes.
This order is challenged.
Yes.
Now you also will find this petitioner had filed the suit in OS number 1912 but the also will find that page 40 annexure B.
OS number 1912.
1912 for 2001.
Yes.
This was contested by the respondent. A decree was passed on merits.
Yes. It was decreed suit for
injunction. The operative portion will also be find at page 65.
65. Permanent injunctions are granted.
Please. In respect of the decretal property.
Yes, sir. Yes.
And the decree will also find the next page 69 and decree.
Correct. Thereafter, he sought to, yes,
This was challenged by the
in RFA.
in RFA. RFA was dismissed. Annexure C.
For each finality.
Therefore, the judgment and decree passed by the trial court at the final. The petitioner had got constructed a shed in the decretal property. He wanted to construct a pakka building. Therefore, he has obtained. It was the virtually a shed earlier. Annexure D is the plan and license.
Annexure D.
Annexure D, page 75.
Yes, sir.
It is the plan and license obtained from PBL.
Correct.
At that stage, below, the respondent clearing interfered again. Then the execution petition was filed. Annexure D, page 78. At that stage, below, the respondent and her brother colluded with each other and they created a release date. Your lords will find it at Annexure F.
Yes.
On the basis of this release date, he filed a suit and obtained a status quo order.
That
by using that status quo order, they responded to the scheduled property and take it during the pendency of the execution. Then the Lord, I appeared before the trial court and filed my objections. Then the trial court rejected my application, refused to vacate the status quo order. Then the matter was taken before this honorable court. Your lordship will find it at page 91.
MFA.
MFA. This honorable court, considering all these aspects, vacated the status quo order. Annexure D.
Petition sector, the question.
The operating portion, your lordship will find it at page.
So 106 operative.
Please. 100. Page 100. Page
106.
100. I did not 101. Then the Lord, after getting this order from this honorable court, the Lord, in the execution petition, I filed an application for arresting the judgment debtor. The trial court stated rejected that application also, saying that I have to go to the civil court by filing another suit. That order I have challenged before this honorable court, and action H is the order. Action H, page 101.
101.
101. This honorable court had directed the trial court to consider my application for arrest of the judgment debtor and for detention. Within a prescribed period.
Within a period of 8 weeks. Yes.
106.
Yes.
My lord, by this time, my lord, the judgment debtor, the decree holder, the petitioner hearing is out of possession during the pendency of the execution proceedings. Therefore, I filed an application. Action J may kindly be obtained.
Then you have to be restored.
I have to be restored in possession. For that reason, I have filed an application. The learned judge, even without calling for objections, stated a rejected application, saying that I should go for another.
Yes. We
Therefore, I am before.
Which for the other side? The Arkeshwar.
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 T.N. Arkeshwar. G.M. Manjunatha.
Good. Ordinary counsel appearing for the petitioner. Petitioner in part. Let this matter next week on 2:30. 90 9 to 2:30. We will give one more opportunity for him. Ordinary counsel appearing for the petition in part. In order to provide no representation on behalf of the respondent. In order to provide an opportunity to the respondent, list on. So at 2:30. Which is the para, sir?
CRP 25.
CRP 25 to the para?
Para 16 and 18. Para 8, 13, 16 and 18.
2011 2 KCCR. In another judgment by Honorable Justice, yes.
Correct.
Will be para 11.
ILR Karnataka 2002. Para?
Para 11.
I will look at it.
In para 12, you got to have differentiated the earlier procedure and the present procedure. First one is amendment of
Chamber. Yes. Please pass on. Just note down the paras and yes. Yes. File culture. Yes. 47 Govindraj. Yes.
Petition arises for proceedings for execution of a compromise between a father and the son. The son files a partition suit. In lieu of continued enjoyment of the entire property, he enters a compromise petition in Annexure A.
What is challenge in this?
Two orders, my lords. First,
Annexure F.
directed us to file a memo of calculation. The watchers may kindly take page number 23. I only read one paragraph.
Who appears for the others? Can you take up any other 2 weeks? 2 weeks. Because these are all 21 matters.
No, my lords. I may apply one development on 18 to 2022 February.
Because this is with regard to recovery of money.
That's all. And the second order is where the
Lana Council appearing for a petitioner present. No representation on behalf of the respondent. In order to provide an opportunity to the respondent, list on 10 days before. 10 days.
14?
Yes.
Serial number 48.
Shivananda is? Yes, sir.
Shivananda is?
Yes, Govindra, sir. What is this? Shivananda is?
Shivananda is?
What is challenge in this? Annexure F, Allah. Annexure F. Order 8 rule 1 and 10 of the permit them to file return statement. Just to delay statement.
My lords.
Yes, delay of both the applications. Yes, sir. Even otherwise, any of that Salem, it is only a directive. We accepted with cost. At what stage it is filed? Yes, sir. At what stage it is filed?
Before the commencement of evidence.
Then we will give an opportunity.
The reasons given by the applicant. But I will only show few facts not in the case. But he appeared on 7/10/2000.
No, that is drafted by the advocate. Reasons is given. No. I know. Yes. Yes. Suit person? Allow with cost.
He says, counsel prepared the draft of the return statement, sent it thrice to the address furnished in the plaintiff. But can it be believed, not always the advocate will have the contact details?
Yes.
That is the reason not given by the.
So that cannot be accepted, of course. We will give an opportunity. Anyway, the suit will be effectively, it will be decided. That is very important, ultimately. So we will impose cost of 10,000.
He appeared on 7/10/17 and filed the IA on 14/8/2019.
He appeared on?
7/10/17.
Yes, sir.
IA filed on 14/8/2019.
2 years or nothing.
That to kindly see the circumstances. Not when the application for DI was argued.
At that time he filed it.
After completion of the arguments on the side of the plaintiff, not D7 wanted to argue the matter. Then an overall objection was raised stating that unless he files a written statement or objections to the IF or TA, he cannot have any say in the matter.
Yes.
When that objection was raised, on the next day also he did not do anything.
We'll allow with the past. Better. Third. Again. This repetition. Please run. This repetition is filed by the defendant. Defendant number 7. Defendant number 7 in OS number 6032 of 2017, dismissing application filed under 8 Rule 1 and 10 of CPC. The respondent 1 2.
My lords, can I make a mention, my lords?
1 to 3 have filed suit in OS number 6032 of 2017 on the file of the trial court seeking relief of a permanent injunction against the defendants. After 30 permanent injunction. Publishing any message or title in the television, social media, so on. Anything? After the defendant's entered appearance, entered appearance. However, the defendant number 7 has not filed a written statement as per Order 8 Rule 1 of CPC within the stipulated period. And accordingly, when the matter was set down for evidence, when the matter was set down for
My lords,
yes,
may I mention, my lords? My lords, I appeal for the petitioner. Senior is held up in traffic, my lord, since short date may be granted, my lords.
yes. Very well, very well.
Much obliged.
Yes. And thereafter, the defendant number 7 has filed application under Order 8 Rule 1 and 10 and seeking permission from the court to file written statement. The said application was resisted by the plaintiff. The trial court, after considering the material and record by its order dated 17th January 2020, rejected the application and being agreed by the same, the defendant number 7 has preferred this petition. I heard Sri Samit S. Lana counsel appearing for the petitioner and Sri Govind Raju Lana counsel appearing for the plaintiffs. Plaintiff/respondent number 1 to 3. Submit to SAMMI. And a counsel appealing for the petitioner contended that the finding recorded by the trial court rejecting the IA filed by the defendant number 7 seeking to file a written statement is not correct. It is also stated in the petition. It is also submitted that the trial court has not properly considered the averments made in the affidavit accompanying the application while rejecting the application filed by the defendant number 7. Accordingly, when a counsel appealing for the petitioner sought interference of this court in this petition. Per contrast, Sri Govind Raju and counsel appealing for the plaintiff contended that the defendant number 7 had appeared before the trial court on 7/10/2017 and he has slept over the matter for a considerable period and filed the application along with the written statement on 14/8/2019 belatedly, and therefore he contended that the finding recorded by the trial court is just and proper, which cannot be interfered in this petition. In the light of the submission made by the Lana counsel appealing for the parties and following the law declared by the apex court in the Salem 2006 Salem Advocates Association and Salem Advocates 2005 and the 2005 alla ಇನ್ನೊಂದಿದೆ ಈಗ ರೀಸೆಂಟ್ ಅಂತ and ಇನ್ನೊಂದಿದೆ 2019 ಒಂದಿದೆ. And so, the period stipulated in the Order 8, Rule 1 of CPC is not mandatory and it is directory. And allowing the said application belated shall be based on the reasons stipulated in the affidavit. Full stop. In the full stop. Taking a full stop. Having taken note of the law declared by this court, having taken note of the law declared by the apex court in the aforementioned case, the suit is one filed for permanent injunction, and ಬೇರೆ ಫೈಲ್ ಮಾಡಿದಾರಲ್ಲ others have filed written statement. ಅಲ್ಲ anyway we will allow it fast.
They have only filed
no written statement.
And their prayer, when this is a prayer, it is also not specific.
Yes.
They say we may be permitted to adopt the written
Statement
or
is.
we may be permitted to file the written.
Yes, it is there. Para 2 nalli. Énaಯ್ತು? Injunction and in the interest of justice and considering the nature of the suit, I am of the opinion that that in order to decide the case effectively by the trial court, the written statement, the defendant number 7 be allowed to file a written statement. Accordingly, the writ petition is allowed. However, I find source in the submission made by Sri Govind Raju that though the defendant number 7 appeared on 7/10/2017, however, the written statement was not filed. And on the other hand, the defendant number 7 has filed an application on 14/8/2019 19. Full stop. Taking into consideration, the submission made by the Lana Council appealing for the respondent number 1 to 7, I'm of chief, the writ petition is to be allowed with the cost of rupees 10,000 to be payable by the defendant number 7 to the plaintiffs. Ordered accordingly.
Grateful.
Huh?
Whether they should adopt or to file a petition.
Full stop.
But they have left it to the court. That is not.
Not anyway, that we will see. In the event, Tony, if the defendant number 7 wish to file return statement, and say may be filed within 7 days from today. Yes.
Number 49 is Sunil Shakti.
In the first matter, my lord, I appear for the petitioner.
Yes, sir.
Lord, matter pertains to my lord.
1 minute, sir.
Yes, please.
Tomorrow. Next week, sir. Abhinav, next
Yes,
week,
please,
this week's time.
Very well.
2 weeks, 2 weeks.
But the interim order in the first matter may be extended.
Yes. In the first matter, 49.
Yes.
49. Lana Council appealing for the petitioner present. Lana Council appealing for the respondent number 1 and 2 seeks a short accommodation. This matters after 2 weeks. After 2 weeks, interim order granted earlier is extended till next date of hearing in WP number 14586 up to 2021.
I'm grateful.
Yes, sir. What is the challenge? Annexure yet. Same pleading application. Order 6 to 17. You are the plaintiff. Suit for declaration. Yes. At what stage the application was filed? At what stage that you have filed? At what stage? Belated means what stage? What is sought to amend actually?
Item number 2 of the suit property is 1 gunta of land, which has fallen to the share of the plaintiff in a registered partition between the plaintiff, defendant, and 1 more brother.
Yes.
The plaintiff share is 1 gunta, whereas the defendant share is 3 guntas. Including this 1 gunta, he has enforced and constructed a house in the after filing of this suit. So that is why an idea was filed for measurement and demarcation. The commissioner's report and case shows the defendant has entered on 1 gunta of land and constructed the house.
Yes, sir.
In the written statement to document kindly.
That will change the nature of the suit. That will change the nature of the suit. That will change the nature of the suit.
No. The evidence is there. Evidence is there to the effect that he has encroached on the. No doubt, it changes the nature of the
suit. Firstly, after 8 years of delay of 8 years. Secondly, insofar as it will change the nature of the not a case for it. Yes, even otherwise.
He says, I am not in possession of the property.
Yes.
I am not in possession.
Because it will introduce a new cause of action. It will introduce a new cause of action.
Yes.
That cannot be. Yes.
He has encroached. The defendant has encroached 1 gunta of land.
Yes, sir. And that is only after the evidence. Where is that? or writ petition is allowed.
It was allowed and the order appointing the court commissioner was set aside.
You copy to one copy to him. If you have a copy, just. Yes, Karegoda, not a case for him.
Whatever there is delay in filing the application.
But that itself is sufficient.
But the evidence and record shows that he has enclosed even 1 foot of land which has fallen to the share of the plaintiff in the registered partition. Apart from that, he has taken 3 acres of land.
Yes.
Defeating the rights of the plaintiff and another brother.
But it will change it, introduce a new cause of action. No doubt on the right. Order 670 is no doubt is sufficient.
Well, problem is but he has constructed a house, enclosing the
Anyway, court commissioner already this court, in fact, allowed the writ petition filed by them on 8th February 2020. Sandesh Madikar, MS Shankar Goli, Berry Sorry. This writ petition is filed.
For mandatory injunction.
Yes. This writ petition is filed by the plaintiff in OS number 9 of 2013 on the file of the Principal Civil Judge and JMFC Chellakere. Dismissing IA number 10. Brief facts for the purpose of adjudication of this writ petition are that the plaintiff has filed suit for declaration with consequential relief of permanent injunction and for mandatory injunction to make haddbast of the suit scheduled properties. In this said suit, the defendant entered appearance and contested the matter. After the completion of the evidence, the plaintiff has filed IA number 10 under order 6 rule 17 of CPC and sought to amend the plaint, and the said application was resisted by the defendant. The trial court, after considering the material and record, by its order dated 14th December 2021, rejected the application, and being agreed by the same, the plaintiff has presented this petition. I heard Sri Patel D. Karegowda, and a counsel appearing for the plaintiff / petitioner, and Sri so and so. You had appeared. Sandesh P. Nadager, advocate for G. Balakrishna Sastry, and a counsel appearing for the respondent. Sri Patel Karegowda, and a counsel appearing for the petitioner, contended that the finding recorded by the trial court that the application seeking amendment of the plaint was filed at the belated stage at the time of the reply is not correct. He further submitted that in the event if the amendment is not amendment application is not allowed, the plaintiff would be put to hardship, and accordingly he submitted that the finding recorded by the trial court is required to be interfered in this petition. Per contra, Mr. So and so. Yes.
This 44, there is no dispute because the defendant also does not dispute the possession of the plaintiff over the item number 2 of the scheduled property.
Next story. No. He further contended that the respondent himself has encroached 1 gunta of land in survey number 28/2, now renamed as survey number 28/3 after his son, and therefore the finding recorded by the trial court is requires to be included in this report. Per contra, Mr. So-and-so sought to justify the impugned order passed by the trial court. Here, he further submitted that this court in WP number 54668 of 2017, dated 8 February 2021, allowed the application filed by the defendant under order 26 rule 9 read with section 151 of CPC. Accordingly, he submitted that since this application seeking amendment was filed after 8 years and same cannot, and there is no therefore he submitted that the petition deserves to be dismissed. Having heard the learned counsel appearing for the parties and carefully considered I carefully examined the finding recorded by the trial court. Undisputably, suit is filed for declaration with consequential relief. Application has been filed by the plaintiff after the completion of the evidence, that too TWO, and that too after 8 years of the filing of the suit. The trial court, having taken note of the averments made in the affidavit accompanying the application, had come to a conclusion that there is no averment in the application, that the plaintiff had taken due diligence in defense with regard to raising the new ground at the time of after the completion of the trial. And in that view of the matter, taking into consideration that the law declared by this court in the case of Arvind Kumar Saib, taking into account the law declared by the apex court in the case of Revatiju Builders and Developers versus Narayana, reported in 2009-10 SCC 84. I am of the view that the finding recorded by the trial court is just and proper. It does not call for any interference in this writ petition. Accordingly, writ petition is rejected. Yes, madam. Past. Yes, madam.
Please, my lord, I appear for the petitioner. My lord. Senior counsel is appearing in the matter, Lord.
Yes. Nothing. Just we will go by the facts. The only matter left out for me today. We will go very slowly. One minute. Just what is challenge, madam? What is challenge?
Under section 34, I had a right to file objections. There's a delay in filing the objections.
Where is the impugned order actually? 23/12/2021 annexure A is challenge. Yes. Annexure A. Annexure A is challenge. IAS number 2 and 3 filed. This is. Now, what is challenge in this writ petition? Dated 23/12. Where is that one?
It is at 208. It was attached in the end.
208. Order on IA number 2 and 3.
Please.
1. Yes. So petitioner is the
Petitioners United Spirits.
is the what is the rank in
He's the claimant.
claimant in arbitration?
Claimant in arbitration. Which
Yes.
came to be dismissed, and therefore we filed this section 30.
Section 30.
Respondent is United Breweries.
So you filed the appeal under section 34.
They filed it. United Spirits.
They filed
Who's the
it.
respondent?
Yes.
Now, the respondent in section 34 is United Breweries.
Yes.
Who is under liquidation, and therefore the official liquidators representing them.
Yes.
Now, the official liquidator should have filed his objections on time, and he did not file his objections. That's the only issue here.
Yes.
Now, the reason that he does not permit us to file this, that there is an extraordinary delay, and that we were not, we were negligent. That is the finding at
Yes.
page 208.
Yes.
At page 208, Your Lordship, first respondent is absent and learned from the petitioner filed written arguments along with submission of relevant arbitration records prior to its oral arguments. Since the first respondent continuously absent and even failed to file written statement,
Yes.
after COVID-19 pandemic, when the courts commenced hearing on 30/1/2021, after nearly 2 years from date of appearance, first respondent appeared and sought for time to file objection. Instead of filing objection, memo came to be filed by first respondent, and even for that memo, the first respondent did not submit anything and remained absent. And without submitting on memo, the present applications are filed belatedly, and therefore there is no question of allowing IAS beyond 120 days. Your Lordship, also the finding that we were negligent, Your Lordship, the next page, at page 209, reasons.
Yes.
Learned counsel to respond one would argue that though when the case is posted for arguments are made, learned counsel for petitioner is absent and the case was posted for hearing, and learned counsel for first respondent has last transferred 3/9/2021. On the said day, learned counsel for respondent one sought time to produce documents, and when the case was posted for the same, present applications came to be filed. The argument of the learned counsel for respondent one would be that since officer in charge of the file was retired by then, the file could not be traced out, and as per the direction of the special judge CBI Bombay,
Whether under the provisions of arbitration period may be enlarged.
Arbitration period can be
Period.
but the arbitration is concluded and I lost it.
You lost it, you filed 34.
In the 34 objections to the 34 petition is not.
That's all. And what happens is he does again.
Whether such provision is there, like filing of written statement in arbitration, whether such any imperative is there, it has to be filed within a time or like that.
There is no provision saying file or not.
Reasonable period if you want to file it.
Commercial courts are correct.
Oh, the commercial court, it is there.
In Commercial Courts Act also, Your Lordship, what
Yes.
happens is it's therefore written statement later. Even the written statement varala, because we are not raising pleadings on the basis of written statement.
Yes, yes.
It would be only on the basis of objections,
Yes.
direct arguments. There is they file their section 34.
34
and
and objection then it will be yes.
Now, Your Lordship,
It is nothing but a first appeal.
correct.
Nothing but first appeal.
So what has happened here is, Your Lordship, in fact, when we filed our wakalat in this matter, Your Lordship, in fact, they had to seek permission from the our Honorable High Court in the Companies Court to even seek leave to file this arbitration. When they sought leave, we personally said we have no objection. They have a right to file that. Parallelly, they go ahead. I was present in that matter even then. I have also filed my wakalat in this matter at that point of time. Just immediately after that, designation happened. Therefore, I cannot appear. What had happened is that that court said NOC pending. Now, the OS office tells NOC for it. So we had to explain concept of NOC will not be there because after designation, we cease to hold a wakalat. That court could not understand that, and later on this matter was transferred. Now, all of this I can't put down in an affidavit, Your Lordship. It won't be right on the court. Subsequently, what happened, Your Lordship?
Yes.
The person who was in charge of this file in the OL's office retired. Nobody seems to know what is going on.
Yes.
Then when the court rule changed, respondents were diligent enough to send us one more notice to the official liquidator's office.
Yes.
That notice also has gone into the file where this person who's retired is not informed.
Yes.
During COVID, Your Lordship, all central government offices had to maintain only 50% capacity.
Yes.
Your Lordship, at that point of time, for these people to figure out which file what was very difficult. Your Lordship, there is absolutely, we're not condoning our delay or we are not condoning our actions. All we are saying is nothing is lost if we are permitted to file. Another thing, this is not where we can drag on. We on the last day, the learned judge in the commercial court told us, you file your written arguments, I'm going to post it for judgments and kept it for 8. We file our written arguments also. All I want is, along with the written arguments, permit me to file that objection statement. The only reason, Your Lordship, is this matter will go to Supreme Court. And the memo that the learned judge is talking about, Your Lordship, the reason that memo was filed is to tell that honorable court that the matter may not proceed because the issue is still pending in Supreme Court. Lordship, what had happened in this matter is United Spirits has sued United Breweries to recover a certain amount of over 1,000 crores.
Yes.
Your Lordship, what had happened is before Justice Ramar Reddy, when he was sitting single in the company court, they sought leave to divest some shares that United Spirits held in United Breweries so as to get some money to pay off all the creditors.
Yes.
What happened is when they sought that permission before that court, they didn't make the banks and all of them parties. So that order came to be challenged by the banks before the division bench, and division bench Justice Kumar passed an order saying that cannot be done. When the matter is pending liquidation here, you cannot divest any shares.
Yes.
That matter is pending in the Supreme Court. Then that very same matter, and there they sought for interim order. Interim order, instead of granting them interim order, staying the division bench's order, instead the reverse order is passed by the Supreme Court stating no further action can be taken when the order of the division bench speaks about not initiating anything else. So there is a reverse order of stay on them. This being the case, it is the very same issue which is in arbitration. Therefore, we file a memo stating, since it's pending in Supreme Court, the Supreme Court decides on the aspect. Because Your Lordship, if the Supreme Court for a minute observes that the division bench was wrong, that the share of shares was okay, then the question of us paying would not arise. Therefore, we felt that let the Supreme Court decide. Now, if the honorable court feels no, I will not pay the Supreme Court. At least I should put my points across. What the learned judge says is, anyway, FISA developers' judgment is there. In FISA developers' judgment, they say even if you don't file your objections, it's okay because you have a right to file written argument.
Written argument.
There's a slight difference only because tomorrow Supreme Court can question there is central government authority. How come you did not file your objections in that? That is all. It is because of diligence that we have to show to file.
Yes.
The other aspect is 2018 I filed my Bakali. I have not filed my objections all right. Yes. From 2018 to 2022, why did the court not proceed and pass the orders? Why did the respondents not argue the matter?
Yes.
It is not because of me that there is any delay.
Yes.
At not one stage the court says for arguments, post for judgment. Not one stage. So from 2018 to 2022, the court has delayed, respondents have not proceeded. It is not because of us. When we realize that it has not proceeded, immediately we can consult leave. Now the court says, no, I will not grant you. The problem there is, I believe, just the cases in the cases here to own their work. I am going to dispose of something. I'm saying I will not delay. Give me 1 day I file objections. Next day I will argue. The date of judgment can be the same on 8 as they have posted it. We will not delay at all. Some costs has to be imposed on us, we are willing to pay. That is all.
Yes, Mr. Only insofar as the scope of this IA. Yes.
Made some submission on the leave granted by United States and how the division bench
that cannot be. We confine to the.
That's actually not an intelligence because it was banks were a party and banks moved an appeal and not despite that the status quo order.
Yes.
Does not also say no further action.
Yes.
When we say status quo, the transaction not approved, we that as a that's not the merits.
Yes.
Now, quite simply put, as far as this case is concerned, two things. One is, if you also please to look at section 34.
Okay.
Very nice. This is again, I learned from express an apprehension that she, there is a chance that the OL will end up having to pay. I don't think that arises. Let me just make that clear. Even if I succeed in this petition, there's no question of it. I want to make it. If I succeed in this petition, the best remedy I have is that I go into arbitration. That's it. I will still have to go into arbitration. She will still get notice. She will still not be able to file her objections in the arbitration. I will let in evidence. She will cross-examine. She gets in evidence. I will cross-examine.
So it will continue.
That's all. That is the short answer to her agitation and grievance.
Yeah.
Let us rest assured that I cannot. But okay, let me put it in this way. I make a claim for 1,300 crores before the arbitral tribunal. According to me wrongly, perhaps according to her rightly, the arbitral tribunal rejects my claim. They do not make a counter claim. It's a very unique situation where I make a claim and I lost, and therefore, fortunately, that doesn't mean fortunately I did not enter the arbitration. Award is against me. What is my remedy? I have to go 34.
34.
Award set aside.
Yes.
What happens upon award being set aside? Either the award, the arbitration is demanded back to the same tribunal or fresh arbitration. That's all.
That's all.
No grievance anybody is put to. This matter, I don't know why the different things to go up to the Supreme Court. At best, suppose I succeed, there is a fresh arbitration, fresh notices ordered to her, fresh objections on merits. Secondly, suppose the OL feels agreed that even the 34 petition should not have been allowed, we can there is a 37. That's all. And that's on a very limited ground. If anything, I respectfully submit. If at all my petition is dismissed, much like my claim was dismissed, I may move a 37.
37?
I don't know why they will move a 37 if at all, because let me just show you that position of law. Other than and the delay that is caused, that is point out these two aspects. I am really not going to go into that status quo because that's all nice. Please see section 34.
Yes, sir.
Recourse to a court against arbitral award may be made only on an application for setting aside such award in accordance with subsection 2 or subsection 3. Arbitral award, subsection 2, may be set aside by the court only if A, the party making the application, that is me,
yes,
establishes on the basis of the record of the arbitral tribunal. Please appreciate this. Earlier, Melanchthon is right in pointing out FISA developers and saying that it can be done in written arguments. Even FISA has been watered down in view of the amendment in 2018. Melanchthon is right because from 2015 to 2019 the position was, and therefore the judgment in FISA developers, that you can prove your case on affidavits if necessary, but no cross-examination.
That's
What is the case?
another Justice Ravindra.
Justice Ravindra. But now there is a judgment of the Honorable Supreme Court, there are two workplaces that, where Canara Lead and one more, where they say that in view of the 2019 judgment, even FISA is not necessary. There is no question of even affidavit, unless I am alleging that there is some impropriety. I am not making any such allegation. I am quite sure I will confirm that. Indeed, on day one, I asked for notice to be dispatched to the arbitrators. Suppose I am making an allegation to a party and then say that they have to meet that allegation of. I would not even imagine making such an allegation in this case. But in a given case, let us say that there is an allegation of corruption or fraud or something else, that I have to prove by way of it. That is not, I am not again proving my claim in the arbitration. I am only proving a ground under 34, if at all. But even that has now been done away with in 2019, and the amendment to section 34 2A says,
yes,
party making the application, and the burden is entirely on me, has to establish on the basis of the arbitral award, record the arbitral tribunal that whatever grounds are. Of course, the public policy is available, whatever it will be, but nonetheless, it is only on the basis of the records that are available. Public policy stands outside of that. I am not, but anyway, I can't prove public. Of course, if it is corruption, I have to let it in. Suppose it is fraud and alleging, right, not fraud in this case.
That's to prove.
Hypothetically, I say that the arbitrator and not the other side had some collusion or something. If that is not the case, under 34, onus is on me to establish only on the basis of the arbitral record. That is exactly what the learned judge concludes in this application, because under subsection 6, he is under pressure to complete the proceedings within 1 month. My knowledge is right. 3-4 years have elapsed. We went from one court to another, first non-commercial, then commercial. All of this is happening. I cannot give the matter of it. Absolutely. But the fact is, for whatever reason the matter is taken up, it's not taken up. Secondly, as far as the other submission I made that where is McDonald?
What is the position of law after visa actually change?
I will point. Let me first point that out and then I will. But please take the judgment of the Supreme Court in McDonald first. Just to first tell your lordships that. Let me not put it.
McDonald, yes.
McDonald. But suppose my petition is allowed, what happens? That is the best case I can have. The answer is in paragraph 52.
52. Yes.
52. Internal page 208. Classical.
1996.
1996 Act makes provision for the supervisory role of courts for the review of the arbitral award only to ensure fairness. Intervention of the court is envisaged in certain circumstances only, like in case of fraud or bias or by the arbitrators, violation of natural justice, etc. Court cannot correct the errors of the arbitrator. It can only quash the award, leaving the parties free to begin arbitration again if it so desire. So the scheme of the provision aims to keep the supervisory role of the court at minimum. So I have to reinitiate arbitration.
Only remand.
That's all. I get another day in. Well, I should not say another day in court because it's a day before the tribunal, but that's all there is to it. Secondly, this fits in with the scope of section 43 of the Act.
Yes.
Of the Arbitration Act. Subsection 4 of section 43 relating to limitations.
That's what prior to amendment.
This provision is not amended, so it doesn't really matter.
But ಅದೇ ಇದೆಯಾ? ಹಳೇದು ಇದೆಯಾ? ಹೌದು. ಇಲ್ಲ ಅದನ್ನ GMCPC court prior amendment. So those books will be given.
There is one more thing I want to speak to the court. There is now a commercial division constituted in our High Court. Here is speaking perhaps for the state. But even GMCPC or group design matters arising out of the commercial court should perhaps go something to it.
It may require.
Quite recently, the commercial division has been lost.
Please pass it.
But I can pass on my copy and.
Yes, yes. 43 ಅಲ್ಲ ಸರ್?
Oh, limitation.
43. Shall apply to for the purpose of this section. An arbitration shall be deemed to have.
Please turn to subsection. Subsection 4.
Where the court orders
that an arbitral award be set aside. The period between the commencement of the arbitration and the date of the order of the court shall be excluded in computing the time prescribed by Limitation Act. Also, for the commencement of arbitration, commencement of proceedings, including arbitration with respect to the dispute. So suppose this award is set aside and my petition is allowed on the basis of the material that's before the court. Then, in order to reinitiate arbitration, the time spent between my original notice of arbitration and
till the completion
order in my favor is excluded for my fresh arbitration.
It's like section 14 of limitation.
That is the second section. Then, my lord, the next aspect is on visa developers, which your lordship would ask me. Please permit me to place the judgment.
Yes.
Judgment in NK.
Because what has happened now, so any number of judgments on 34, 37, I think it is confusion.
Latest NHA is something that has redetermined everything.
Yes,
please turn to paragraph 17 of the judgment.
13 is also, in para 13 visa.
Yes, I'm ready for that. I point out from there.
Para 13.
Yes, I read from there. Para 13. Now we come to a judgment of this court in visa developers. I'm sorry, before that, please permit me to show your lordships what the controversy here was. It's again relating to stock exchange arbitration. Please come to 13. Now we come to the judgment of the sporting Fizar developers. In this case, the question that was posed by the court was whether issues as contemplated under Order 14(1) should be framed in applications under Section 34. This court held in the summary proceeding, the respondent is given an opportunity to file his objections or written statement. Thereafter, the court will permit the parties to file affidavits in proof of their respective stands, and if necessary, permit cross-examination by the other side after hearing arguments. Framing of issues in such proceedings is not necessary. We hasten to add that when it is said issues are not necessary, it does not mean that evidence is not necessary. Then they also say in paragraph 17, scheme and provisions of the Act disclose two significant aspects relating to courts vis-a-vis arbitration. The first is that there should be minimal interference by courts in matters related to arbitration. Second is the sense of urgency shown, etc. Then I'll skip the rest of the lordship.
Yes.
Permit me to read paragraph 31 at the bottom of
Yes.
16. Applications under Section 34 are summary proceedings with provisions or objections by the respondent defendant following an opportunity to the applicant to prove the existence of any ground under Section 34(2). The applicant is permitted to file affidavits of his witness in proof. A corresponding opportunity is given to the respondent to place his evidence by affidavit. Where the case so warrants, court permits cross-examination of the person swearing to the affidavit. Thereafter, court hears arguments and receives written submissions to decide the matter. This is the routine procedure. Court will vary the said procedure depending on facts of the case. What is clear is framing of issues in matters.
Yes.
Now, please turn to paragraph 17.
Yes.
And then thereafter, the subsequent judgments are analyzed. A recent report of Justice B. Sri Krishna Committee to review the institutionalization of arbitration mechanism has found amendment to Section 34(2)(a) of AC, subsection 2(a) of Section 34 provides for setting aside of arbitral awards by the court in certain circumstances. Party applying for setting aside the arbitral award has to furnish proof to the court. This requirement to furnish proof has led to inconsistent practices in some high courts, where they have insisted on Section 34 proceedings being conducted in the manner of a regular civil suit. This is despite the Supreme Court ruling in Fizar developers that proceedings under 34 should not be conducted in the same manner as civil suit, with framing issues under Rule 1 of Order 14. In this light, the committee is of the view that suitable amendment may be made to 34(2)(a) to ensure proceedings under 34 are conducted expeditiously. Recommendation is, please see this over the page. An amendment may be made to Section 34(2)(a), substituting the words furnishes proof with the words establishes on the basis of the arbitral data. That is what is now transferred because of the 2019.
Yes.
Please then see paragraph 19. One more recent development in the law of arbitration needs to be adverted to. After the decision in Fizar developers, Section 34 was amended by Section so and so, by the Act of so and so, in which subsections 5 and 6 were added to the Principal Act with effect from 23/10/2015, which reads as follows. These are the two provisions where they say that prior notice is necessary and that it should be done expeditiously.
34, 5 and 6.
Yes, absolutely. Paragraph 21. It will thus be seen that speedy resolution of arbitral disputes has been the reasoning for enacting of 1996 Act and continues to be the reason for adding amendments to the said Act to strengthen the aforesaid objective. Quite obviously, if issues are to be framed and oral evidence taken in a summary proceeding under Section 34, this object will be defeated. It is also on the cards that if bill number so and so is passed, that evidence at the stage of Section 34 application will be dispensed with altogether. Given the current state of law, we are of the view that two earlier High Court judgments, Delhi High Court judgments, cited by us herein above, correctly reflect the position of law as to furnishing of proof under 34(2)(a). So does the Calcutta High Court judgment. We may hasten to add that if the procedure followed by Punjab and Haryana High Court judgment is to be adhered to, the time limit of 1 year would only be observed in most cases in the breach. We therefore overrule this decision. We are constrained to observe that Fizar developers was a step in the right direction, as its ultimate ratio is that issues need not be struck at the stage of hearing of 34 applications in summary procedure. However, this judgment must now be read in the light of the amendment made to sections 34(5) and 34(6). So read, we clarify the legal position by stating that an application for setting aside an arbitral award will not ordinarily require anything beyond the record that was before the arbitrator. However, if there are matters not contained in such record and are relevant to the determination of the issues under Section 34(2)(a), they may be brought to the notice of the court by way of affidavits filed by both parties. Cross-examination of persons swearing to affidavits should not be allowed unless absolutely necessary, as a truth will emerge on the reading of the affidavits by the court. This makes it clear, therefore, if even affidavit is not necessary, I have to prove my case only on the basis of it. If I transgress beyond the record, only then the respondent has to then make good and say, no, this is beyond the record of order. Now, the lordship may take it that I have not. I have placed perhaps 3 or 4 volumes, and all of which are only what is put on arbitration. Then, my lord, comes the judgment in Karnataka. I'm sorry, my lord, I'm taking up some of your lordship's time.
No, nothing.
I just wanted to point out one other thing. Prior in sequence to FISA, under the 1940 Act, before the coming into force of the 1996 Act, under section 30 and 23 of the 1940 Act, there was a provision where a party agreed to challenge both the award as well as the agreement. I could have challenged even the agreement. But also under sections 14 and 17 of that Act, they had to file the award in court to make it a rule of law. So typically what used to happen was when a petition is filed under 14 and 17, the respondent would say that I am challenging the very award as well as the agreement, and therefore 30 and 33. They would convert it into an arbitration suit, and that would go on forever. There again the question
now
of
it is streamlined.
Because there the scope was much larger. All of that is now done away with. FISA first said something, then the amendment came, then this judgment in NK Global said no, all that is unnecessary. Petitioner has to prove on the basis of the record only. If he is transgressing beyond, then you it. Now, then comes the judgment in Karnataka.
Yes.
Please. So the reason I'm pointing out Karnataka is that please notice paragraph 2. These appeals arise out of judgment dated 12/9/2014 passed by the High Court. But they apply the principles under the 2019 after the amendment. That's the reason I'm pointing this. Please turn to paragraph 17 and 18.
Yes.
Based on the Justice Sri Krishna report, section 34 has been amended by the Arbitration Application Act as under section 34. The words furnishes proof that is substituted to the words establishes on the basis of the record the arbitration that is substituted. 18. After referring to the Justice Sri Krishna report and other judgments and observing that the decision in FISA must be read in the light of the amendment made to 35.4 and 35.6 and the amendment to 34, section 34 in NK Global, it was held that I passed on.
Yes.
Please turn over the page. I'll skip reading what is extracted from NK Global. Classicum D,
yes.
The legal position is thus clarified that section 34 application will not ordinarily require anything beyond the record that was before the arbitrator, and cross-examination of persons swearing into the agreement should not be allowed. They reiterate the position, but they just apply this even to proceedings which had begun under the 2014 Act. So that question of saying it's not retrospective also goes. I'm actually making things tougher for myself. So my burden in the section 34 court to that extent is tougher and it's narrow. I'm conscious of it. I'm placing the legal position before you. This is the second submission.
It's very tough for the applicant. No.
I am for the applicant in the section 34.
34. It's very tough now.
It is very tough. I'm fully aware
to prove within the framework of 34.
Which is why I said I don't think the situation will arise from a learning field to the first submission was that if at all I succeed, I go back to arbitration, then I get a mark. Second submission is that this question of having to file objections or to raise any ground may not be necessary in view of this. The burden is entirely on me and on the basis of the record. Thirdly, please turn to the order sheet and just point out a few small things and then
there is various dates, even the learned judges. The case was called on so and so.
Please turn to in page 108 from the order sheet.
108.
Yes. I'm sorry, I stand corrected. 106. 106. That was the 20.
106.
I apologize if the dates are page numbers.
106.
Order dated 28/1/2019.
Correct. 106.
This was the day in 2019 that the objection was taken as not filed.
For statement of objection not filed.
Yes.
For statement of objection not filed.
Quite.
Yes.
Thereafter, we had to under the commercial court side, the practices we have to file written submissions first and only then we have to file the records of the arbitration, written submissions and the oral arguments in that order. Then again the case can be transferred there and subsequently right. Please then turn to in page 111, order dated 7/9/2022. Sorry, 7/9/2020.
Order dated?
7/9, I'm sorry, 7/9/2020.
Correct, in your closure of course.
Yes, but on the left hand side, there is a notation of the change of account.
Hmm.
I'm only bringing to the court's notice. Please see over the page 23/2/2021.
Yes.
This is
27.
learned counsel for petitioner and respondent present. Learned counsel for respondent files memo for consideration of memo and arbitration. This is the memo where they talk about the Supreme Court pending matter. I respectfully submit that cannot be correct. I filed a reply to that. On the next day, you also notice I filed a reply to that. Thereafter, that the memo is also not argued, and instead, they filed this application on 23/9/2022. So when compared to the first day on which it was taken as not filed, it's well over 2.5 years. And the not filed occurred well before the COVID. That's what I want. And so I'm not pointing fingers at anybody, but even after that, fresh Vakala is filed after a year, after roughly a year, a memo is filed, and thereafter the notice is filed, and nothing is done thereafter. And ultimately, they have not filed written arguments. I have no quarrel with that. Opportunity was given for oral arguments. They have not awaited. But at that time, this is the legal submission.
Yes.
Your Lordship, is that because I can give it up? Kindly see last but one page, which is a 212.
212.
Please. The first one is there.
Yes.
Since the commercial courts not only govern the provisions of CPC but also provisions of Commercial Courts Act of 2015, arbitration suit came to be filed after amendment to Arbitration Conciliation Act and Commercial Courts Act in 2015 and 2018. Therefore, the objection statement cannot be received unless bona fide reasons are made out. The affidavit of respondent number 1 reveals about the negligence on the part of the official in charge of the file who said to have been retired from service. Therefore, the said reason cannot be treated as bona fide reasons to receive the objection statement. First respondent cannot take advantage of his own fault and decision of Apex Court regarding the extension of limitation due to COVID-19 pandemic. Further, since it is a petition under 34, not filing objection statement will not make much as scope is limited as held in the decision if visa developers. Hence, I answer the point in negative. Now, I am not going by it. This court has gone by it, and therefore, I am trying to say the court feels that anyway you have a chance for all the arguments which are purely academic, which have absolutely nothing to do with this. The Lordship NHAI's judgment is very clear. After that, the only thing that is available under 34 is either it can be set aside or it can be. That is all. And even for you to go back for fresh, it is not such an easy procedure. I am not going to give another academic session on that. Now, all the judgments relied on matter and all of that ultimately have no bearing in this matter, and therefore I have not burdened your Lordship with any of that.
I will.
The question that your Lordship put very straight respondent answered, is there any bar? There is no temporary. Now, I would not want to even otherwise mislead your Lordship, and therefore one of the latest judgments which I wanted to state, which will also not have a bearing on us, is Supreme Court decision. I've written it and given it to the court officer. This is, your Lordship, is a very small portion which I will read.
Yes.
It's Shaurat Singh versus Charan Singh, which is decided on 8/10/2021, which is one of the most latest. Defendant appellant is in an appeal against an order passed by High Court in Allahabad, wherein written statement filed by defendant was not permitted to be taken on record as it was filed beyond 90 days fixed under Order 8 Rule 1 of CTC. We find that High Court is completely misdirected itself and not taking the written statement on record in view of the judgments in Kailash versus so-and-so and the association in Tamil Nadu versus India, wherein it was held period of 90 days to file a written statement is direct rule. It may be stated herein that the provisions of Order 8 Rule 1 of CPC are mandatory in the commercial courts under Commercial Courts Act of 2015. In view of the said fact, order passed by High Court is set aside. Consequently, appeals allowed. Matters limited to the court to decide suit on merits after taking into consideration the written statement already filed by defendant appellant as early as possible. This matter also, though they say that commercial courts it could be applicable 90 days mandatory, it is ultimately under Order 8.
Then director.
Therefore, yes.
Then,
therefore, there is a difference, and therefore, for an objection, your lordship. Therefore, that's why I wanted to bring this judgment also to your lordship's notice, because we don't want to suppress anything. All these judgments ultimately are academic. The question put forth to both of us is there a time frame by which time I should file my objections? No. There even arbitration in under 34. Now, your lordship, I'm glad that he pointed out who the order sheet. Your lordships kindly see the order sheet. Yes, in 2020 they filed a color, but continuously all we say is plaintiff prays for time, plaintiff prays for time, plaintiff prays for time. There is no portion anywhere in the order sheet which says respondent prays for time. Your lordship, and from 2020 till 2022, SOP was in force. Now the court does not want to go into the SOP. SOP is binding on them, your lordship. Yet he says no. And where there is an SOP, even that there is an alternative, the Commercial Court Act, the Commercial Court does not want to look at it. Now, the last submission made that they had an opportunity to argue, but they did not argue. The lordship matter before your lordship. And the reason it was adjourned to today was because your lordship, I was to produce the Supreme Court judgment and also the judgments as I mentioned about our single bench and division bench, your lordship.
Then filing is directory. Now Salem Advocates Association. Then again we have to go to Constitution bench. If it is related to order 8.
Difficulty, as I say, if you go back, but the point is even if it goes back, what we are doing is we're protecting the rights of the creditors. Ultimately, that is my job. I cannot over 1,000 crores be non-diligent. Your lordship, Supreme Court judgment.
This is
yeah, yes. Now they stated that is not what it is. What I mentioned about the Supreme Court. So I will leave your lordship to take the record. There are 2 lines of the Supreme Court judgment. The last page. Last page. Third, learned counsel for petitioners, exemption granted, permission to file synopsis, list of dates is granted, so and so issue notice. In the meanwhile, there shall be status quo with regard to the transaction which has not been approved by the division bench in the impugned order.
It's not been approved.
Yes. There is a status quo. Your lordship, I read it again. There shall be a status quo with regard to the transaction which has not been approved by the division bench. Meaning you cannot proceed. The division bench has said the transaction is not correct. Meaning you can't go any further from that. Therefore, there is a reverse order on them. And that is why the memo came to be filed by the OL stating that when the matter is pending in Supreme Court, why go ahead? Might as well they decide on it and then we proceed. Still, we did not want to. See, also there is no delay from our part, despite the fact that yes, there has been delayed filing objections. We have not elongated the matter. We have not gone and taken a stay somewhere. And as a result of us, there is a delay. As a result of us, there has been no delay. If the court was to pass judgment, we could have passed it 2 years ago or 3 years ago. They did not do it. But now I am not delaying it. 8 is for judgment. Written arguments have been filed. Permit me to argue it. And also file on record. There will be no harm to anybody in this matter.
You made the court to open the eyes. That's why they opened. If you were to be continued, then the court would not have filed even this order, present order.
Unfortunately, we come on record and then they wake up and they say, now we will go ahead.
Yes.
And it would not be fair both on the court's part and on the claimant's part at this stage to say, no, you don't have a right to file objections.
Yes,
because
yes.
they sat on it for so long.
That will necessitate by having to go to the bench, which I did
Need
not.
not
But then she brought it up, so therefore.
only confined to the IA, that's all.
This is not a submission that's on that IA. That's what I'm trying to find out. The transaction that is not permitted by the High Division bench. The reason that is stated so is we pointed out to the Supreme Court that by then the transaction is already completed. After it was completed, the division bench sought to set it aside. After between the time that the learned citizen gave us permission, appeals were filed, and the division bench set it aside, the transaction was completed.
Yes.
Therefore, the language is this. If my learned friend is pointing out that, she should pointing this out, she should point out that also. Anyway, leave that as it is. That's not this. What I am submitting is, for my to answer my learned friend's, I don't know, that judgment is not got a copy of, not a translated. But it seems to say, but whatever the judgment is, does not apply to commercial courts. If that is so, then it is.
No, it applies to the commercial.
Sorry, I am telling you what you read out.
I just read out.
But you didn't give me a copy, so I don't have the benefit of seeing it.
I will read it out again. I should read it, just that line, I should read it again.
Stated, so far as, I
It
think,
may be stated
just
that provisions of order rate.
one minute,
Mandatory.
one minute.
Yes, it is.
Read where are you reading?
Please pay a paragraph 4, your lordship.
Yes, it may be stated here.
Please, that the provisions of order rate rule 1 of CPC are
One minute.
mandatory in the commercial codes under the Commercial Codes Act of 2015. Therefore, under Commercial Codes Act, these are not the only matters and several matters. So under order rate, it is mandatory that they follow that. No written statement is not available in this. I am not going to read evidence on this matter. It is just a matter of objections, and therefore that will not arise. And that is specifically an order rate. That is all I'm saying.
Yes, very good. I will pass out this.
Your Lordship, until such time stay, because these proceedings with judgment, it is released for 80.
Sure.
8.
Ardilana Council, Ardilana Senior Council representing the parties. Interim order granted earlier, extended till next week.
It is fresh matter.
Fresh matter. Oh, it is not yet.
Last time it came up in the hearing. I don't know how it's come for a year.
I think it was because of the IAS.
It is not listed for
Please, Your Lordship.
It was listed for preliminary hearing only.
petition.
I think because of the pending IAS, Your Lordship, maybe.
Just 1 minute.
But the Lordship were to say that judgment not to be pronounced, if not already pronounced, I have no problem. I don't think I should.
It's not.
Should not agree because it's still 8.
Just 1 minute. Just I will look at the prayer sought in the. Sometimes in GMCP there is no prayer for interim ruling. They will argue the matter. I come across a day before.
They sought for a stay of proceedings. Since it's for judgment, your Lordship simply said judgment not being pronounced, it's not already.
Matter consider interim prayer immediately in your urgency. Great. Where madam the interim prayer is sorting page just stay further proceedings in commercial AS number 142 of 2018 pending adjudication before the commercial court at Bangalore until further on.
The only reason I'm saying is also that the judgment not be pronounced it's not a stay of further proceedings.
Further all proceedings. All further proceedings. Yes, ma'am. Will be done. Student culture. Reserve. Third and reserve. Because what will happen if we say there was sitting with Honorable Justice Sujata Madam.
Yes, sorry, Your Lordship.
No, nothing there. No, not today. Not today. Certain arbitration matters will come. Certain judgments will be posed. Thereafter, another roster I will go somewhere else, Dharwad or Kalburgi. Again, I will be back. Some new judgments will come in arbitration. Nanda Kumar is
Has come up with so many judgments. Your Lordship.
It is our privilege to keep citing.
It's very difficult where when the particular principle has started, where it has gone, how it is modified, and subsequently what is the end point. It's very difficult. Yes, ultimately, sometimes we will forgotten what is the provision contemplated in the act. Yes. Very well. That's good.
Court officer. Court officer.
ಹಲೋ ಹೇಳಿ.
ಸರ್ ಇದು ಸೀರಿಯಲ್ ನಂಬರ್ 49 ಏನಾಯ್ತು ಸರ್? ಅದ್ರಲ್ಲಿ ಸ್ಟೇ ಇತ್ತು.
ಮೇಡಮ್ ಮೆತ್ತಿಗೆ
ನಮ್ಗೆ
ಎಕ್ಸ್ಟೆಂಡ್ ಆಗಿದೆ.
ಹೌದಾ?